no desire to go learn something else.
Hearing. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston, within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Well, good morning, everybody, and welcome to one of two sessions of the Appeals Court that's going on today. It's Friday, October 10, 2025. Your panel today is me. I'm Greg Massing. To my right is Justice Sachs. To my left is Justice Allen. We'll be hearing 6 cases today. I know you guys know the rules, but it's 15 minutes per side, no rebuttal. We'll hear them in order, so I thank you all for being here on time, but if you're being heard later in the day, you can feel free to, wander the halls, look at the portraits, or just stay here and see what kind of mood we're in. We have all your materials on our iPads here, so we've read them. We're familiar with the cases, so there's no need to much preamble. You can go right into it. 15 minutes goes by very quickly. That said, there's no penalty for finishing early, and I think that's all for all the announcements. So, first case we're hearing today is John Doe, number 526-823 versus Sex Offender Registry Board, 24P777.
Good morning, Your Honors. Fred Burkholder on behalf of John Doe, 526-823. Your Honors, in reviewing the materials that were submitted by my brother and myself, I don't see a great need in repeating what we wrote. I think my brother's brief is well written. I think I've highlighted what I think the primary issues are. So obviously I respond to any questions, but I'd only like to highlight a couple things that I think are glaring. I first want to talk about my brother's contention that the issue of hearsay was not raised at the lower level. On pages 266 to 269 of my record, which were pages 13 through 16 of the original transcript, there is an objection that was raised by prior counsel. It references hearsay. It even references the discrepancy that exists within the hearsay, which is the basis of my contention. So with all due respect to my brother, I think the issue was properly raised.
What about at the Superior Court level?
Yeah, to my knowledge, it was not raised in the Superior Court. I don't know that waives it. I did some quick research to see if it does. I couldn't find any case that says it does. If I am wrong, I stand corrected and we go forward. That said, why is it relevant? What's interesting in how the analysis of Dr. Johnson's opinion is, and whether or not there's a objectively valid reason to reject it, is her consideration of 2 factors. One being the extra vulnerability of the victim, and the second one is whether or not there was penetration. What I find ironic is this. There was no analysis in the decision, both the first one and after the remand, that talks about the substantial reliability of that witness. Maybe that was convenient, and I say that for the following reason. Because to be found extra vulnerable in this case, of course, was the result of intoxication. Intoxication, of course, impacts memory, impacts detail, impacts the like. So if you're extra vulnerable, as the hearing examiner says and finds, then how can you also make credible determinations or credible statements?
So factor 19 is degree of physical contact.
That's correct.
That's the one at issue. That goes to degree of dangerousness.
It certainly does.
Is that correct? Dr. Johnson was qualified as an expert on assessment of risk of sex offender recidivism, which sounds to me like expert on risk of reoffense.
That's
Why
correct.
does whether she properly considered a factor that goes to degree of dangerousness even relevant to her opinion?
Because the case law that I read says 23656 is probably the predominant case with regards to evaluation of expert opinion. Reads that the hearing examiner is able to review their analysis of the factors in comparison with the analysis of the hearing exam, or of the expert analysis of the factors, and then make a determination. I saw no discrimination within that case site or the mandates that were provided that discriminates between dangerousness risk factor or risk of reoffense factor.
I agree that sometimes they're blurred together, but she's specifically qualified on the issue of risk of reoffense.
That's totally true.
I know that she goes through and has a little list in her report that goes through all 38 factors and says whether she thinks they're applicable, or if not, why not. But where she's qualified as an expert on risk of reoffense, why does her opinion on the factors that relate to degree of dangerousness, why does that even come in?
I think for the reasons that I previously stated, and there's no reason to repeat it, and again, if I'm wrong, then I stand corrected. That said, I also think it's relevant to the second argument which I make, which is the analysis of dangerousness, and whether or not internet publication has any efficacy in the situation. Because again, if you get to a situation where there is no credible evidence that was found of penetration, then to make the jump to moderate level dangerousness, and therefore the need for any internet publication, takes us back to 496-501 and says we are required to look at these things on a continuum, and without that penetration, you know, we don't have as severe of offense. It becomes a much clearer or much cloudier issue.
So the examiner relied on 4 factors in particular in addressing degree of dangerousness. Factor 18, extra vulnerable victim. Factor 10, Doe's criminal history. Factor 11, history of non-sexual violence. Factor 13, prior probation violation.
That's correct.
Also relied on factor 19, so that would be the 5th factor. If that one factor were left out, is it plausible to think that the examiner would have found a low degree of dangerousness rather than merely rather than a moderate degree, which is what you found?
I do, and for the following reason. And this is maybe how Dr. Johnson's report comes into play in that regard. Dr. Johnson's report talks about the Doe not having the indicators of recidivism that ordinarily are present, such as sexual deviancy, repetitive and compulsive conduct, and the like. So I think it comes into play in that regard, in that if you take out that factor, I think you go back to Doe 496-501 and makes us look at the degree of offense on a continuum, and it's a much closer case, especially when you have an individual who has one isolated offense. It was clearly the result, or to a great degree, substance abuse contributed to it occurring, and that substance abuse is being addressed. Maybe he didn't do sex offender treatment, but he certainly addressed substance abuse, and that's one of the significant factors in this case, is because if you look at his record, sure, he's got 3 probation violations. But other than that, you look at his criminal record, he's got 9, as my brother points out, he's got 9 convictions. He's got only 1 conviction for a violent offense outside of a sexual offense, and that was an assault and battery. I think it was back in 2011. So it's dated. So those factors are not overwhelming, at least in my opinion.
Was that one a domestic?
Yes.
Assault and battery? Okay.
Yes.
Yeah.
But it was dated. It was some time ago.
Right. But you know, in looking at the hearing examiner's second pass at Dr. Johnson, it seems, you know, to be less, to sort of step back a little, it seems like what's going on is that Dr. Johnson treated Doe as a person with a drinking problem and not as a sex offender. And the hearing examiner treated him as a sex offender who also had a drinking problem.
Yes, but I don't agree with that completely, and I'll tell you why. And prior counsel at the MJOP level did a very good job of pointing out a couple things, and I'll point them out. First of all, Dr. Johnson agrees that CRA is not sex offender treatment. Secondly, Dr. Johnson never says that her opinion is based upon maintaining sobriety of Doe. She considered and gave him credit for the insight of the impact that alcohol had upon his life, and acknowledging that he will have to demonstrate his ability to maintain that in the future when he's released. And she also, of course, offers an explanation of the deviation that studies overwhelmingly show that one individual to one offense, in fact, have a lower risk. So I guess what I'm trying to say by all that is she didn't do what the hearing examiner tries to say, which is, okay, she found that he's going to maintain sobriety and therefore his problems are all solved. She never says that. She gives him credit for working upon it, but she also, and I have a lot of respect for this particular expert because of, frankly, the quality of the report, plus my familiarity with from other hearings and cases. She looks at really what sex offender treatment's all about, and that is when you get into, especially like at the MTC level, you get into stage 1 and it's just basically a recognition of what it's all about. You get into phase 2, then it's more of an identification of what is the problem that exists, and then the later stages, of course, are how to address it. I think that his recognition that substance abuse was a problem puts him somewhere in what would be the focus of stage 2. And then if he completes the CRA program and the like. So just because you don't call it SOTP doesn't mean he didn't receive what is, and again, we're supposed to do individualized hearings. We can't just put the blanket over, in my opinion, you can't just put the blanket over and say, well, you didn't do SOTP, so therefore, I mean, it reminds me of Hill in the SDP cases, which is, you didn't do it, so therefore. It doesn't look at what you know, as I understand SORB litigation, it's not just you did it before and therefore it can be inferred that you did it in the future. This guy has done things to address what he deemed to be his critical problem. I wish there would have been evidence as to why his parole was denied other than to simply say he didn't do SOTP. My question is, why didn't he do it? Of course, when you want it to be in the record.
I was going to ask SORB that. Is there any evidence of a violation of parole not being allowed? There's a question from the...
I'm not aware of any violation of parole, but if I understand why it was
not
denied,
violation of not being granted.
I think it's talked about by, I think it might be in his web index at some point, but I didn't pull that out to point out to you the page. You know, as soon as you start talking about individuals that didn't go through SOTP and that are not at Mass Treatment Center, then you have to think, well, why didn't they do it? Unfortunately, I can't make that argument because I don't know why he didn't do it, but there's certainly the possibility he didn't do it because, you know, I mean, those things are not confidential. And we all know that if it's not confidential and you waive based upon a lack of confidentiality, you can't consider it at all. But I'm not even going there. I think that Dr. Johnson didn't say he wouldn't benefit from SOTP. She never said that. She said what he did inspired me, encouraged me, and the like. Certainly he has some history of going back out after maintaining some degree of sobriety, but because of the depth of the analysis that she put into factors and because the evidence with regards to extra vulnerability is sketchy at best, at least in my opinion, again, I mean, how can he be extra vulnerable and make credible statements? Pick one. You know, I know, whatever, I'll argue it accordingly, but I don't, they're two sides of a different coin as far as I'm concerned. I don't know if that answers your question.
All right. Thank you.
Thank you.
Good morning. May it please the court, Christopher Bover on behalf of the board. Just touching upon the arguments that my brother has brought up in his oral arguments here today. With respect to the hearsay argument, I'll start off. As I indicated in the board's brief, this has been waived. I understand that it was brought up at the hearing level, but I would suggest, as I argued in the brief, that it was done in more of a general scope. If you look at the transcript, the counsel representing the plaintiff in this particular case objected to, I believe it was 5 tabs within the board's evidence. There were multiple police reports, some of them were the same. And just as I object on the grounds of hearsay, saying that they're inconsistent statements and whatnot.
So I have a question.
Go ahead.
have a question about why that isn't sufficient. Because the way the examiner addresses it, and I don't remember if this was in the transcript, but it was certainly the final decision of the examiner, was, no, I'm going to let it in, and then I'll determine with each individual piece of evidence whether it's reliable, what weight to give it. So what more is an offender supposed to do other than say, I object to the hearsay in the Boston police report, and get that answer? The offender isn't in the examiner's mind to know what weight the examiner is going to give each piece of hearsay, how reliable it's going to be deemed, and then to make objections about specific
And if I
pieces.
can just add to Justice Sachs's question, what the objection is, it's hearsay without corroboration consistency, which are two of the things that we asked for in the reliability assessment.
Yeah, and certainly I understand, Justice Massing, that is the end-all, be-all in terms of the review for hearsay statements in these proceedings. What I will say to that is that in this particular case, you have the district court documents that says that the offender was initially charged in district court with rape, and then he was charged with assault to rape, indecent assault, and battery, moving forward into Superior Court. So within the record evidence itself that was presented, that the board was presenting, that information was key. And in the openings, I believe it was mentioned in the openings in terms of what the board's case was going to be. So in this particular case, when he said the focus of the objection, when you look at the transcript, was on the inconsistent statements between the plaintiff and the victim. In this particular case, the plaintiff said that they essentially did nothing and they walked away, all right? And the victim obviously was saying to the people who responded what she believed that the plaintiff did to her. So in this particular case, the focus was not necessarily on the level of penetration. The focus was on the inconsistent statements. Now, the hearing examiner didn't really say it in the decision, and I concede that, but the guilty finding in itself goes to the credibility of the victim and what she said. So for those reasons, I believe that it was a general in scope because they didn't specifically say, hey.
But the guilty finding didn't require a finding of penetration.
No, it did not, but it certainly boosts the credibility of the victim who made the statements. And I would suggest that's in the case law rather routinely in terms of guilty findings in and of itself, even if they're to lesser charges, will boost the credibility of those underlying hearsay statements. And with respect to the issue...
So just before we get off of Justice Sachs' question, so what is the counsel for Doe supposed to do to say, I want you to find reliability?
Well, in terms of at the hearing, it's a specific objection saying that there should be no finding of penetration given the facts as they're stated in the evidence, because the victim in this case specifically said that the petitioner digitally penetrated her vagina. So that's the evidence that needs to be specifically objected to, rather than focusing on inconsistent statements between the victim and the petitioner. With that being said, there's also another level, and I think Justice Sachs had mentioned it. I would suggest that even if it's protected at the hearing level, it was abandoned at the Superior Court level. And I would suggest it can't not now be renewed at this level when it wasn't an avenue of the petitioner's motion for judgment on pleadings before the Superior Court. Lastly, even if this court were to consider it to get through to this level, I would suggest, and I understand the hearing examiner didn't necessarily give the usual writing with respect to hearsay evidence in terms of consistency corroboration. I'd ask Your Honors look to three particular parts of the decision. While he didn't necessarily cite to the case law, I would suggest that in his recitation of the facts, he did so, and he considered the evidence, and you'll find it. One is right at the beginning of the hearing examiner decision when he specifically rules on the motion. That was discussed in the hearing level that Justice Mashing, you talked about, what the hearing examiner spoke of with respect to hearsay evidence. Two, I'd ask you to look at the facts of the case section in the decision, where he specifically goes through in detail what the victim said. And then lastly, I'd ask you to look at the discussion section, which again, the hearing examiner goes through the facts of the case. So I think as a whole, as you review the decision, even if we were to get to this level, I think that the hearing examiner did enough to indicate that the objection was worthy and that he did find the victim's statements to be consistent, corroborated, and the like.
As Justice Massing mentioned, one of the specific objections raised at the hearing was that the hearsay in the police reports was layered. So as I understand it, this statement is the victim's statement to the EMT, which was said privately, according to the police report. The EMT then obviously relayed it to the police officer. The police officer put it in the report, and then the report comes in at the hearing. So that seems to me to be triple hearsay. And while we know that the EMT's report to the police officer might be reliable because it's a crime to lie to a police officer, and the police officer's report might be reliable because it's a crime to falsify a report, we don't have any such assurance as to the victim's statement to the EMT that started it all. And that goes to Mr. Burkholder's point about the victim being quite intoxicated at the time, and you know, therefore, at least there's a question about reliability.
I would disagree with my brother on that issue. I don't necessarily think that just because it's described as an individual being highly intoxicated doesn't mean that they don't realize that somebody is digitally penetrating their vagina. That is usually an event that the victims remember no matter what. So the fact that this individual was intoxicated, no doubt. It was mentioned by the police. The hearing examiner adopted that in the decision, obviously. But when an individual is digitally penetrating your vagina, you typically remember that. It's reliable. The hearing examiner is allowed to use that. I would suggest that he did that appropriately.
Oh, but would you agree that this is triple hearsay?
I would agree with that. I don't necessarily think that means that it has to be stricken. Again, I understand the hearing examiner did not do the typical evaluation of hearsay evidence as we would normally see. That is not contained in the decision. I understand that. However, as I indicated, I would ask you to look at those 3 separate sections in the decision that would give you an understanding of where the hearing examiner is coming from in terms of his review of that evidence. Specifically with the objection and the overruling of the objection to the hearsay, again, the recitation of the facts and the fact that he used that in the discussion session would indicate that he did find that information reliable, and he did find it corroborated by the conviction and the other information.
I mean, I think it's implicit that where the hearing examiner relies on it, the hearing examiner views it as reliable. What's missing is the explanation of why.
True, but again, in terms of where he's objecting and where he's overruling the objection in the first part of the decision, essentially cut and paste that part, put it in the fact section. You have the reason in terms of why he viewed the information to be reliable.
Dr. Johnson said that I'm not going to consider penetration. Was that because she thought the hearsay was unreliable, or because that was not the offense that he was convicted of?
That particular question, Your Honor, I don't necessarily think was explored during the examination of Dr. Johnson, neither on direct or cross-examination, that specific question. As I recall the transcript testimony from the doctor, she said that this information, he was not charged with it, he was not convicted of it, meaning the penetrative offense. Therefore, she wasn't going to consider it as such because he was neither charged nor convicted of that information. I don't think it was asked specifically on cross-examination by the board counsel, did you actually find penetration? I think she answered it with respect to he wasn't charged, he wasn't convicted, therefore it didn't happen.
What about, there's a question, at the hearing, the counsel for the board asks Dr. Johnson, did you consider that he was denied parole for failure, for not participating in sex offender treatment? And her answer is, I don't recall if I read that or not. Apart from that question, is there something in the record that actually documents the denial of parole for that reason?
I wish I knew that answer, Your Honor. I don't recall it. It wasn't something that counsel necessarily pinpointed in his brief, or if he did, I didn't pick up on it, so I don't have the specific answer for you. I apologize. But as counsel indicated, if it were to be in that, the answer would be found usually in that DOC parole information, which is the client index and the WebEx information that is controlled there. Just touching upon the expert opinion a little bit more, in terms of the case law, you have to have careful consideration and you have to be able to articulate the reasons why you diverge from the expert's opinion in the decision. And I think the hearing examiner actually did that. The hearing examiner noted several factors that he disagreed with Dr. Johnson. And Dr. Henry, who is the hearing examiner, specifically went over the Factor 9, the substance abuse issue, in depth in his decision as to why he believed the importance of not only having substance abuse treatment. By the way, the Dr. Henry also mentioned that he hadn't had any type of outside activity in terms of being offense-free with respect to substance abuse. He was still incarcerated at the time of the hearing, so he hadn't been out in the community to meet that factor or give it full weight, I should say. In addition, and I think it was found in depth in the cross-examination with respect to Factor 24, there is a difference between the CRA Academy and the sex offender treatment care while incarcerated. There's a difference between that, and I think the hearing examiner noted the difference. Also, I think it's important that the hearing examiner specifically noted in the decision where he disagreed with Dr. Johnson, not necessarily in Factor 35 where he talked about Dr. Johnson's expert report and testimony, but under the regular factors that he talked about. He disagreed with the doctor in terms of the probation mitigating factor as well as the age mitigating factor, which in both of those instances, Dr. Johnson gave mitigating weight for that. The hearing examiner looked at those two factors and said, well, wait a second, this particular offender had multiple probation violations, so I'm not going to give full risk mitigating weight. Also, with respect to the age, Dr. Johnson in a report credited age as a mitigating risk factor, and the hearing examiner said, wait a minute, he offended only 4 years before, and he showed an active sex drive, so under the regulations, he didn't give that as much weight as well. So when you look at those factors combined with factors 18 and 19, which we discussed was extra vulnerable victim as well as level of contact, I think the hearing examiner pinpointed up to 5 or 6 regulatory factors where he diverged from the doctor. So with respect to that, again, careful consideration, I think the hearing examiner did that, and articulate in the decision why he disagreed with the expert, and I think he did that as well. And then that just leaves us with the substantial evidence argument. I won't go into great detail, but I would suggest that the hearing examiner's decision would indicate that he weighed the competing factors, the risk aggravating factors, the risk elevating factors, as well as the risk mitigating factors. And I would suggest that the decision is supported by substantial evidence, and therefore we would ask that you affirm the decision here today. And unless there's any other questions from the panel, I'll rest on my brief.
Okay, thank you. Thank you both. Very, very well argued, and we'll take it. It'll take under advisement.
Thank you so much. Have a good long weekend.
You too. All right. The next case that we're going to be hearing is New England Carpenters Central Collection Agency Trustee versus Arch Insurance Company 25P74. I just got to say, we've seen lots of SORB cases before. I've never seen one of these before.
All right, okay. Well, happy to be the first. May it please the court, Luke Liakos on behalf of my clients, the appellants here, at the time called the New England Carpenters Central Collections Agency, along with various fringe benefit funds affiliated with the North Atlantic States Regional Council of Carpenters, who for brevity's sake, this morning I'll refer to either as the union or the Carpenters Union. So at stake here are the retirement and health insurance benefits of working people, essential workers, who build our schools, libraries, public safety buildings, courthouses, etc. The statutory interpretation urged by Arch Insurance would prevent the funding of those benefits. So there's a lot at stake. The statute at issue...
Well, I mean, why can't you get it from the contractor or the subcontractor? I mean, the bond is helpful, but I mean, why isn't the first line of, like, to ask, you know, Galaxy and Mass Construction, pay us the benefits?
So the record is, I think, underdeveloped on this issue, but I can assure you, just in working with fringe benefit funds as part of my practice, every effort by law, by ERISA, has to be exhausted. So the delinquent subcontractors were pursued, and I can represent to this court, as far as I know, and I checked recently, neither subcontractor is in operation today, so they've gone under. So to use an expression, it's kind of like a blood from a stone situation. But again, the trustees of these funds have the highest fiduciary duty under American jurisprudence to the participants. So they have to exhaust every remedy, I assure you, to recover. So the statute issue is...
Can I ask you another procedural question? How is the information gained by the trustees relative to when the benefits are not being collected? So how did the information come to the trustees of this delinquency, and when, and how, and because I think that's relevant to some of your arguments. So how is the information collected and provided to you?
So in practice, per the collective bargaining agreement, every month, a signatory contractor has to pay contributions for each hour worked by a carpenter. So those are usually due on the 15th of every month. So when they don't come into the fund office, the trustees are notified. The plan administrator will notify the trustees.
So you get some sort of report every 30 days then?
In the event of a contractor delinquency, it could be within that timeline. It could be immediate, where the plan administrator authorized to act on behalf of the trustees would know immediately if there was a delinquent subcontractor.
Okay, go ahead.
And just to follow up on that, in the summary judgment decision, there was talk about whether there was a material dispute of fact about the timing of the request. And I think you've abandoned, in your brief, any argument that we made a proper within 65 days request. I think you're right. You're saying either we didn't have to, or I mean, you're saying we didn't have to.
That's a fair way to put it.
Yeah.
It's, the trial judge made a finding on that issue, finding the notice premature. That finding is not challenged as part of this appeal.
To follow up further on Justice Allen's question, you've explained how trustees get notice of whether a contractor has made payments. How do trustees get notified, if at all, when the union members working for that particular contractor have performed their last day of work on a project?
Well, that's a great question, and that speaks to sort of the inherent unfairness of the trial judge's decision. The trustees may not necessarily be aware of the last day of work, especially in the construction industry context. It's really difficult to track that because a subcontractor may conclude work on Monday. Benefit funds may determine they're delinquent on Tuesday and send that notice to the general contractor of the bond claim. And on Wednesday, the general contractor may call the sub back to the site and say, "Oh, we need you to touch up on this. This isn't done to our satisfaction." So now Wednesday's the last day of work, but you gave notice on Tuesday. So making that determination is very difficult, especially because on the union side, the business agents may have access to a job site, and in fact, in most cases they do. The benefit funds don't have that access by right under a contract.
And is there any requirement that contractors give notice to the trustees when they've considered that they've performed their last day of work?
No, that would be, if that were to exist, it'd be under the collective bargaining agreement, which is not a provision in the applicable one here.
It's a pretty short window. You need to learn that the work is done, and you need to file with the general or give notice to the general within 65 days.
That's right.
Assuming that notice provision applies.
That's right.
What is the logic for having a 65-day notice provision where you have a contractual relationship with a subcontractor but not the general, and then a one-year period where you've got a contractual relationship with the general?
Well, the one-year period with a contractual relationship with the general contractor speaks to, I guess, basically the statute of limitations that you can file a claim in Superior Court seeking payment of the bond. But to your question, what's the logic of requiring the written notice where there's only a contractual relationship with the subcontractor? I'm actually not sure. I could only speculate that it would just be because the general contractor in that instance has no, I'll call it a formal association with the claimant. And again, in the construction industry context, again, when we're not talking about benefit funds, because benefit funds are unique. I mean, I try to make that clear in my brief. They occupy a very unique space here. But if we're talking about a materialman or a subcontractor, frankly, I mean, the GC might not always know who's on site. That's like, sounds bad, and it is bad, but that's the reality of a lot of construction. Less so in public construction, less so for sure, but that's the reality. Whether you have subs of subs, GC might not always be aware of who's providing materials or labor on a project. So I think that's probably, if I had to speculate a little bit, that's probably why there's that notice requirement, where there's no contractual relationship with the GC.
So explain the basis of the contractual agreement that the fund or the trustees have with the general as opposed to the subs.
Thank you, because that's really the heart of this appeal. I mean, it could be, it's actually very simple when you think of it in those terms. So start with the premise, I think we have to start with this premise that benefit funds, as a claimant for a construction bond, they are expressly granted that right by the legislature in the first paragraph of the statute, right at the tail end. So we know that, and specifically Taft-Hartley funds, which is a benefit fund that's funded by a collective bargaining agreement between a union and an employer. So we know that they have standing to pursue a claim under the statute. The legislature expressly granted it to them. It says right in the statute. The term contractual relationship is not defined in 149, and I'm not aware of any case in this context where an appellate court looks at what that term means.
And if you're talking about anybody else in the statute, you know, a provider of materials or whatever, though it's very clear, right, who your contract's with. With you guys, it's not so clear.
I would agree with that.
Yeah.
But again, the fact that they're contemplated in that first paragraph, benefit funds, means, okay, this does apply to them. So on page 16 of my brief, the definition that I give of contractual relationship, derived from Black's Law Dictionary, just giving each word its common sense meaning: contract, relationship.
Can I just see if I understand your basic point, which is that they don't have a direct contractual relationship with either the general or the sub in this instance, but they are a third-party beneficiary of the collective bargaining agreement to which both the general and the sub are parties?
Well, I mean, to be, I think, a little more precise with our terms, they're not a direct party to a contract. The benefit funds are not a direct party to a contract. There's no, I mean, how do we dispute that? But they absolutely have a they absolutely have a contractual relationship with CTA, the GC, on both projects.
And that relationship is that they're a third-party beneficiary? Or is there something else?
I don't think the third-party beneficiary analysis is particularly relevant to this. And I mean that adamantly. I mean, they have a relationship, a contractual relationship with CTA because the contract between the union and CTA grants the benefit funds certain rights, and it imposes corresponding obligations on CTA, and it's really that simple. And I can give you several examples of those rights that otherwise.
But just so we're clear, the trustees, the funds, are not parties to the collective bargaining agreement.
By law,
Signatories. They granted from the face of the collective bargaining agreement, we can see that they have certain rights, and the signatories, the employer signatories, have certain obligations. But I don't see where the funds are parties.
by law, the funds can't be party to a collective bargaining agreement. I mean, that's Taft-Hartley, that's ERISA, they can't be. They have to be legally separate from the union.
Okay. So I guess I'm curious why that doesn't then put them in the category of third-party beneficiaries, both of the collective bargaining agreement to which both the general and the sub. Well,
I think maybe it does. I mean, I'm not, and we're not disputing that as part of this appeal, but I don't think that's necessarily relevant as to whether they have a contractual relationship. I think in determining whether you have a contractual relationship with someone, you should look to, number one, see if there's a contract. Forget who's the parties. Is there a contract? In this case, there is. Does that contract give one party certain rights? Yes, it does. Does that written agreement impose obligations on the other party? Yes, it does. So now they have an association with each other that otherwise wouldn't exist that can be enforced in court. So, or through other means, frankly. So therefore, there's a contractual relationship.
So why doesn't it make sense to in this context, to interpret who is the obligation to and from? The direct obligation is from the subcontractors to the benefit fund, right? You can get the general involved in helping you enforce that, but the direct obligation is from the subcontractor.
Not necessarily, and I'm grateful that you're asking that question, because a lot of times, I might even say oftentimes, the general contractor, like CTA, will directly employ carpenters on a construction project. That happens a lot of times. In this case, again, I don't think the record is clear on this, but let's assume that they did not directly employ any carpenters. Instead, they subcontracted that work. The only reason why CTA was able to subcontract that work was because of Section 3A of the collective bargaining agreement, which I'll represent to this court is on, trying to give you the citation, the record appendix.
192.
There we go. Thank you very much. So 192 of the record appendix. So the only reason why CTA has that right is because it states right in the contract that they are able to subcontract some or all of the carpentry work to a subcontractor, provided that subcontractor is also a signatory. In this case, that's undisputed. They were. But the reason why that's important is because, I mean, let's assume that CTA did employ contractors directly, they would have the same obligation to the benefit funds to contribute a certain amount of money for every hour worked by a carpenter. But regardless of that, so even, assuming for the sake of argument they did not employ directly and carpenters on this project, they still have obligations to, for example, to pay with like a two-party check upon request by NECA, two-party check to the subcontractor with the other party being NECA. Otherwise, the benefit funds would have no right to tell a GC how to make payment to their subcontractor. That right arises under the collective bargaining agreement. There's one point that I want to address in my colleague's brief. I think it appears on page 16. Arch argues that any duty imposed by the CBA upon CTA is a function of CTA's direct contractual relationship with Galaxy and Mass Construction, the delinquent subs. That's just not true. I mean, you can look at the contract. Duties imposed upon CTA arise from its contract with the union. That's where the duties arise from. It could not be more clear. And I gave you an example, the signing of the two-party checks, there's a provision in there saying that the general contractor, upon notice of a delinquency, shall assist the funds in obtaining compliance from the delinquent subcontractor. So that obligation has nothing to do with the contract between CTA and Galaxy or CTA and Mass Construction. That obligation arises as a function of the contract between the union and CTA as a signatory.
Where is the particular provision in the collective bargaining agreement that requires the employer of the carpenters to make the payments to the trustees?
Article 9, I believe. Article 9, I think, speaks to the hourly contributions to the benefit funds.
It says employer, right? I mean, it doesn't specify subcontractor or contract. Just the employer has the obligation.
Right. There's no special contract for subs and GCs. It's an employer. In this case, they're both an employer. They may not be an employer on this particular project, but again, that's only because they've utilized their rights under Section 3A to subcontract the work.
So Article 9 is dues assessment. Article 10 is fringe benefit fund and other payment provisions. But can you point us to the particular section of Article 10 that requires the payments?
I don't have it in front of me. I'm sorry.
Okay.
I know Article 15 speaks to the obligations of CTA to assist in the collection, so it might be in the
Article 10, Section 1 says the trust agreements and other provisions, each employer subscribes to and agrees to be bound by the provisions of the various agreements and declarations of trust. And that lists a bunch of trust funds. Doesn't list NECA, but NECA is sort of is the collection agency for all of those trust funds that are mentioned.
That's exactly right. Yep.
So your time is up. See if there's any other questions. Okay, no, thank you. Very helpful. We'll hear from Arch.
May it please the Court. My name is Mansour Ahmed, and I represent Arch Insurance Company, the appellee in this matter. We ask the Court to affirm the decision of the Superior Court in granting summary judgment in favor of Arch for the following two overarching reasons. First, because under GLC 149, Section 29, the trustees, the plaintiffs in this case, lacked a contractual relationship as defined under Section 149 with the contractor principal furnishing the bond.
Okay, as defined, how is it defined in that section?
I can tell you in multiple ways. There's a second paragraph that defines a contractor principal furnishing a bond. The third paragraph.
Don't go too fast here. I want to get everything you're saying. So the first definition is where
It's not explicitly defined, but it's defined by exclusion. If you look by enumerating the procedure under two possible avenues of relief for a claimant, the first is a contractor principal who has a contractual relationship. The second is parties, any claimant in the third paragraph of Section 29, any claimant having a contractual relationship with a subcontractor. Thus, by exclusion, any party that doesn't have a direct contract must go through that third party or that third paragraph procedure, which is to follow that written notice within 65 days of last providing notice.
Why is that? If they don't, I think I missed something in what you said. If they don't have a contractual relationship with a subcontractor, then why are they subject to the 65-day provision?
If they don't have a contractual relationship with the subcontractor, they do have a contractual relationship in this case, but their contractual relationship flows up through the subcontractor, and therefore it has to be applied through the third paragraph procedure of the 65-day window.
Okay, so you contend that the paragraphs, unfortunately, in Section 29 aren't numbered, but you contend that the one that starts any claimant having a contractual relationship with a subcontractor, blah, 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 but no contractual relationship with the contractor has to follow the 65 days.
But how does that enlighten us what contractual relationship means?
In the context of this matter, contractual relationship in the plethora of construction statutes in the Commonwealth, and this being the public construction statute, it implies by reading the two paragraphs together, the two procedures, one to file a claim within a year for a party having a direct contractual relationship with the principal, CTA in this case, and the second to file that a case within a year plus the written notice within 65 days of the last window. There implies in that a definition that there has to be a direct contractual relationship between the party seeking to exercise its procedures under the second paragraph, which is to simply file a claim or a petition within that year.
But does NECA have a direct contractual relationship with anybody?
I would submit to Your Honor that there's a third-party beneficiary relationship between both CTA and the subcontractors. But in the case of CTA, it's an incidental third-party beneficiary status. And any delinquency that occurs as a result of the employees of Galaxy and Mass Construction, absent the existence of the contract or the subcontract between CTA, Mass Construction, and or Galaxy, there exists no claim. That claim solely comes out of any delinquencies issued by Mass Construction and Galaxy's failure to pay wages, which are what these benefits essentially come down to in a real-world scenario.
The usual distinction is between incidental third-party beneficiaries and intended third-party beneficiaries. Is that correct?
I believe so, yes, Your Honor.
So how can, where Article 15 confers direct rights on NECA to request that the general contractor pay the subs through a two-party check made out to the sub and NECA when payments are delinquent. So that's conferring a direct contractual right on NECA against the general. How is that an incidental beneficiary relationship?
And in that very question, there's the response that it has to be a two-party check in that CTA cannot directly pay the beneficiary funds directly. It has to pay a check to its subcontractors. The contractor it has a written contract with.
Right. But if we're talking about the type of contractual relationship that exists, doesn't that direct mention of NECCA in the contract mean that NECA is an intended third-party beneficiary of the of this contract to which CTA is a signatory? Not an incidental one, not just someone who happens to benefit if the contract is performed, but someone who actually has rights under the contract and who can ask CTA, require CTA to do certain things under the contract.
And in my understanding, I don't believe CTA has the obligation to make that payment directly to, at any point does it become a direct payment situation. It always has a two-party system, as you mentioned.
Sure, but it can be requested by NECCA. NECCA is given a right against CTA under this contract. NECCA is not a party, but where it's given a right, isn't it an intended beneficiary?
I would disagree with Your Honor in the sense that the intended third-party beneficiary status only results from there ever being a subcontract in this situation. And without the subcontractor having employees of its own that are owed benefits from the subcontractor directly, there exists no point that CTA would ever have to make that payment to a beneficiary trust.
This statute is supposed to be construed liberally, right?
Yes.
How does your construction, Arch's construction, further the purposes of the statute?
Although the statute is remedial in nature and to be construed liberally, that notice requirement is very specific, very easy to follow. And as the Barbosa case...
It is if you know whether you're subject to it. And there's some question here. I mean, I think NECA points out in its brief that it's not literally a claimant under this statute, because a claimant is someone who provides labor. It doesn't provide labor. Obviously, it has a right to enforce the statute because it's right there in the statute. Mentioned the trustees can seek payments, but I don't understand why the notice provision, I mean, what's unclear and what perhaps should be given a liberal or remedial construction is what are the procedures that apply to the trustees?
And Your Honor, from the beginning, Arch has always had the position that there is a procedure for which the trustees can recover. It's under that 65-day window written requirement period. And to disrupt that would, as the Barbosa case that I've cited it says, it will ill serves the statutory scheme and would stimulate litigation and would obscure the relatively simple statutory prerequisites upon which all parties in public contracting, including the sureties, presumably rely. And it's worth noting in this case that the trustees attempted to comply with that 65-day window period. They wrote 3 letters prematurely to Arch and CTA Construction attempting to comply with the statute. The Peters case that I've also cited is a subcontractor's employee benefits fund who also is attempting to comply with that 65-day window. So there is a procedure by which the trustees can recover under the bond. Now, if there was a direct contract, they could have filed a direct contract claim or breach of contract, but then there would be no need for this bond statute. So to respond to your question regarding whether there is a procedure, and whether the statute is remedial in nature or to be construed liberally, this court has spoken before that with regard to that strict notice requirement, this court is not willing to expand or go further than allowing a notice to be exceeding or premature or after that 65-day window. And I believe Your Honor had asked the question to my brother about the 65-day window and why it exists, as well as the 1-year window. I can answer that. The 1-year window specifically applies because in the public construction scheme of things, bonds are typically renewed yearly. In the alternative, if there's not a bond claim, the party has up until the statute of limitations of a breach of contract to file a direct claim. But the 1-year period applies to the bond claim, so against Arch Insurance Company in this case. With regard to the 65-day window, as the Barbosa case stated, the statutory scheme, there's General Laws Chapter 3039K and 3039F, in which a subcontractor who completes its work on the project applies for his final payment. The general contractor has 65 days from the day of that application to make its final payment to the subcontractor. Now, if there's claims being made by the subcontractor's trustees in this case, or other parties such as a materialman provider, an employee, and that happens either after that 65-day window or before the 65-day window, then at that point, the CTA, the general contractor has to play a guessing game. It doesn't know whether to withhold funds. It doesn't know which amounts should be applied where. It may end up having to double pay on the same amount of work that was completed. So that 65-day window is very important, and it's thematic throughout the public construction statutes.
So maybe you can enlighten me on one other provision, which I don't know if I don't know if this is raised or talked about, but the 5th paragraph of this towards the end says, the court shall not dismiss any petition on the ground that it was filed before the 65th day after the claim was last performed. I mean, technically, wasn't this filed before the 65th day?
Yes, so I was looking at that statute yesterday, and I haven't seen case law discussing it, but in the context of the statute with all the other paragraphs, the 5th paragraph, I would apply to that contractor or contractor or party who has a contractual relationship with the contractor principal furnishing the bond, because that language specifically refers to a petition. The petition in this case being a complaint, not the written transmission or notice of the amounts due or owing within that 65-day window. And if it intended,
There's no requirement that a petition be, the period for filing with the court is a 1-year period. Why would anybody think that a 65-day period is even relevant to that?
in that same paragraph, Your Honor?
Right. What problem is this designed to head off?
The same problem, sorry,
If the requirement to file with the court is within 1 year, sorry, where is it? But filing a petition in equity within 1 year after the last day labor was performed.
I believe in that context, if the petition was filed too early before the expiration of the 65-day window, the argument would be that that claim should have been processed through the construction contract procedures and you filed it prematurely. But I think the statute is clear that if that complaint is filed too early in the context of a party who has a direct contract with the contractor principal, therefore that case or that complaint cannot explicitly be dismissed. And in that same context, there is no mention of that written notice application. And if the legislature intended to do so, it would have, as is in classic statutory interpretation. I see that my time is expiring, so I'll take any further questions, and I'll conclude that the trustees failed to provide timely statutory notice by providing premature notice. The trustees lacked a contractual relationship with CTA as that term is found under 149, Section 29. The Superior Court correctly granted summary judgment for Arch Insurance, and accordingly, I request that this court affirm the judgment.
I have two other questions. One is, you mention in your brief that the mechanics lien statute provides some guidance. Can you point us to a specific provision of a specific section that you think is relevant?
Yes, GL 254 section, both 2 and 4 discuss, and Your Honor, I've cited, I believe the Barbosa case discusses the nature of the mechanics lien statute being something that is what the bond claim statute was created as an alternative for the mechanics lien statute because the bond claim on a public project, you can't get mechanics lien on a public project. So this was offered as an alternative to that in the sense that parties or subcontractors can be assured of or have some guarantee of payment if the general contractor has any issues.
But is there language in the mechanics lien statute that sheds light on which of the two procedures here NECA should have followed?
Other than explaining that the mechanics lien statute requires strict statutory compliance, I don't have a specific citation for you on that.
And the other question is, even if this notice is premature, the notice is given here, because some labor was performed afterwards, why shouldn't they be good, at least as to the work that was already completed when they were given?
Because it has to be, all of the work has to be something that has to be calculated in that 65-day window because of that final application for payment from the first-tier subcontractor. In this case, the second-tier subcontractor is asking for payment too early. And again, I believe the Carter pile driving case discusses exactly that, a premature notice situation. And with regard to the liberal construction of the statute, it still doesn't allow for a recovery on a premature notice basis.
Thank you.
Thank you, Your Honors.
Thank you both. Really appreciate both of you sharing your expertise with us. It's a very, very interesting case, and it's submitted. Thank you. Thank you. All right. You good for two? You good for two more? Yeah, we're probably going to hear two more cases before our morning recess. So the third case is 24P855, PUOPOLO versus Massport.
Are you ready? Good morning, Your Honors. May it please the Court, my name is Suzanne Harold. I'm here representing Captain Alexander PUOPOLO on an appeal from a full dismissal of his Superior Court complaint. This is a limited appeal. He's appealing counts 2 and 4. Count 2 is an allegation of failure to provide a reasonable accommodation for his disability, which is irritable bowel syndrome. And count 4 is retaliatory termination for exercising his protected right of seeking a reasonable accommodation for his disability.
Okay, and you're not pressing the retaliation for activity regarding officers Matunis and Carew, right?
No.
Okay.
As I mentioned, Captain PUOPOLO has a disability. He requested a reasonable accommodation. And I believe that the court has made an error in making a factual conclusion that is disputed for all intents and purposes, which would negate finding of summary judgment for Massachusetts Port Authority. So essentially what this boils down to is Captain PUOPOLO requested the ability to leave his shift if and when he experienced a flare-up in his disability while working. And at the time, he was assigned to the overnight shift, which just is not staffed as heavily as a day shift would be. And what the record reflects that is disputed, which is a material dispute, is that Massport has taken the position, and the lower court adopted this position, that he was provided a reasonable accommodation because Massport said he could notify the other officers that are working on shift with him as well.
The chalk that we're not letting them use because we have it here pretty clearly says that. It says notify. It doesn't say anything about confirm.
No, that's not true, because if you look at the communication that Captain PUOPOLO received from Human Resources, which I believe is the record appendix pages 93 and 94, the communication to Alex says, you must notify the others on shift, and you must then call she's now a chief or co-chief, Shiska, and another Tian, and they will then respond. So the record is not clear that Captain PUOPOLO just needs to notify individuals.
Well, I mean, it says, you tell them, and then one of them would respond.
Correct.
Meaning they would show up. It sounds like if he gives, so you say, wait, I mean, where does it say that he has to wait to receive confirmation before he can leave?
So the email from Human Resources indicates that they will then respond. In his interrogatory responses, he identifies a situation in which he notifies the people that he is currently on shift with, then follows the instructions to contact Shishka and Tian, and they do not respond. So his interpretation of this email directive is that he needs to get a response from the people that are going to be relieving him. And in this case,
Is there anything else in the record other than his testimony as to that? Did you provide any phone records or emails? He said that he sent an email, he said he called. Did you provide any of that?
No, there's no records of him actually making the phone call, or I don't believe he emailed in that in particular situation. I believe he just made calls, and it was like, he testified that it was like 2 in the morning and nobody was picking up. And that he interpreted that communication, that word response from HR, to mean that he could not leave until he received a response from the commanding officers that would be relieving him.
And where in the record is his interpretation?
It's his interrogatory response number 19. I can give you the appendix pages if you'd like.
Page 90.
Justice Massing says page 90, but
Oh, 90.
where did Mr. PUOPOLO or Captain PUOPOLO ever make that interpretation clear to Massport?
He's interpreting the email that he got that said response.
Right, but where did he ever say to Massport, hey, I interpret this as me not being allowed to leave until somebody actually shows up to cover me?
He didn't say it until this litigation ensued.
Okay, so what about this interactive process that's been referred to, but I don't know that there have been cites about, whether a particular accommodation is reasonable or not. If it's offered, but it's not practical, doesn't the employee have some obligation to get back to the employer and say, this isn't working, or this can't work?
Yes.
And then they work it out further?
Yes, unless there's no reasonable accommodation can be reached,
So how did that happen here? I mean,
So-
it certainly doesn't say on its face that he has to wait until coverage arrives. Interpreted it that way, why didn't he have some obligation to say, hey, I think I have to stay till coverage arrives? That's not practical. What can you do for me?
He has testified that he never attempted to use the accommodation again because when he would make the phone call at 2 in the morning and didn't get a response, he wasn't comfortable leaving, and so he just stuck it out.
He did testify that he did attempt to use it once?
Yes.
And did he say to anyone in HR, this isn't working?
I don't believe so. I think that because he asked for the reasonable accommodation, 2 months later he was terminated. So there wasn't an extensive period of time where he would have used the accommodation, given the fact that it was set in place and 2 months later he was terminated. He did write in his interrogatory responses that he attempted to use the accommodation. He could not reach any of his commanding officers. He was not informed that relief would be coming, and so he stayed.
And
So
can
he
you give
says,
us
sorry, in his interrogatories, he says, I did call, email, and text asking for relief, but none of that was put in the record?
No. Just the fact that he called, but there are no phone records. I do not have a text message for you. I don't have an email.
And he doesn't say that that was at 2 a.m., he just says one night, because when he speaks about 2 a.m., he says, I'm certain that if I called for relief, I would not receive it for hours, but there's nothing to, that never occurred.
Perhaps I'm misremembering the record, but the point is that there is a directive from Human Resources that says somebody will respond, and the court just used the term notify. It ignored the portion of the record that does say that he would get a response, and he was not comfortable leaving without a response, and therefore, when he experienced this flare, he could not utilize his accommodation which we interpret to be an unreasonable accommodation. But the more narrow portion of this is just that the lower court kind of split out the idea that he notify when there is a portion of the record that says somebody will respond. So that is kind of the heart of it as it goes to count 2, and then
Can I just ask one other question?
Certainly.
Can you give us a citation for this interactive process? Is it like an MCAD reg?
Yes.
Reg under the ADA?
both.
Can you, or are there sites in the record?
There should be sites in the record. There are certainly sites in the summary judgment record, which is part of the appendix. But the duty to engage in the interactive process is just something that is part of Chapter 151B, that there has to be a dialogue. There has to be open communication between the employer and the employee. And moving on to count 4, if I may, I believe that there's just been an error of law that has been made by the lower court in terms of temporal proximity with retaliatory conduct and an adverse action. So Captain Popolo asked for a reasonable accommodation in January of 2019. He was terminated 2 months later. The idea that he was terminated for cause and that he can't establish pretext, I believe, is false. I believe that is an error of law. Because within this time period, while the Port Authority is saying to Captain Popolo, you are being terminated for cause, we launched an investigation and we found that, you've committed infractions, we'll say. I think that's the pretextual argument. Captain Popolo does not have to prove pretext. He just needs to kind of point out that the articulated reason for termination is not the true reason for termination. And the lower court concluded that there's no temporal proximity because 2 months had gone by. I would like to point this court to the Verdrager case, which establishes that years can go by before an adverse action is connected to someone having engaged in a protected activity. So in this case, he asks for the accommodation. 2 months later, he's fired. In the meantime, Massport launches an investigation. There's a younger officer, Jenna Carew. And while I've stated to this court that we're not appealing his conduct related to Officer Carew, the investigation is important because Officer Carew makes a complaint that she's hearing rumors within the department that the two of them are sleeping together. In fact, they're family friends. Their grandfathers fought in the military together. They have a long history. They're not having an affair. And when Officer Carew makes this complaint, Massport launches a very detailed investigation into Captain Popolo, but does not interview Officer Carew to confirm or deny what her claims actually are. And instead, this opens up this very broad investigation, finds infractions in which to terminate Captain Popolo. And he's saying this whole time, wait a minute, why isn't anybody talking to me about this? Why isn't anybody talking to Officer Carew about this? That is his argument, that Massport's articulated reason is pretext. And I think the lower court makes an error when it finds that there can't possibly be an inference of a pretextual argument, and that even if there was, the causal connection or the temporal proximity is too great. It's only 2 months. The Verdrager case is telling us that we can look at actions that happened years before. So as to count 4, I also believe the lower court has made an error.
But what is there's two things going on. There's an accommodation request being made and granted, right? I mean, you say it wasn't good enough, but as far as they were concerned, they said you can leave immediately, and then there's an investigation going on. But besides them coinciding in time, what is any evidence that one relates to the other?
Just the fact that he engaged in a protected activity, that the record evidence shows that the actual accommodation was granted on its face, but not in practicality. But that then less than 2 months later, where Massport is going to have to, be involved in a process on an overnight shift to find coverage, that there's, they don't particularly want to do that. And 2 months later, they find a way to escort him out. It's just an argument of temporal proximity, which the law says in the Verdrager case, you can go back years to look at these things. This is merely 2 months.
Actually, I mean, didn't he first make the request in October of 2019? And it was approved. And he wasn't terminated till December of 2020.
The first request for an actual reasonable accommodation came later. He had used FMLA on an intermittent basis, but he had not actually, the interactive process for a reasonable accommodation didn't begin until later. So I think it would have been October 2018, but the actual request didn't come until February of 2019.
But he was disciplined in the middle of all of that initially, correct? There was already discipline in January of 2019.
Yeah, that was part of the investigation. And the investigation was because of Officer Carew. So that her complaint came slightly beforehand.
I just want to be clear. What is the, just, you've said it, but I'm sorry to ask you to repeat it, but what's the evidence that, other than temporal proximity, that a causal connection existed between requesting an accommodation and being terminated? Other than the
Just the timing.
Just the timing.
Yes. Unless the court has any more questions, I'm finished with my presentation.
Okay.
Thank you.
Thank you.
Good morning, Your Honors. May it please the Court, my name is Terrence McCord. I represent Massport. I'm joined today by Amanda Carney, my associate. Summary judgment should be granted in this case because plaintiff has no reasonable expectation of proving essential elements of his claim. In terms of the disability discrimination claim, to make out a disability discrimination claim for failure to provide a reasonable accommodation, there are 4 elements to the claim. The individual is disabled. The individual makes the request for an accommodation. The accommodation is refused by the employer and damages flow therefrom. In this case, the accommodation was requested and was granted. The accommodation, just for the purposes of getting our chronology straight, the investigation that arose with respect to the complaints made by Officer Carew about a romantic relationship was made in December of 19. Right. That investigation revealed that Captain PUOPOLO at the time was actually engaging in practices that suggested favoritism towards Carew. 18 people were interviewed as part of that investigation. And for example, there was evidence that that PUOPOLO would call, even if he wasn't running the shift, he would call the lieutenant running the shift and say, hey, today I need you to move Carew over to, she doesn't want to be at Pierce Park, she wants to be in the Seaport today, so you got to move her. Doing things like that, really showing favoritism. So therefore, on January of 2020, he was issued a suspension. So that's the first piece of discipline. On February 28th...
Let me just ask a question there. It's totally off to the side, but he's a captain. Right. So is he covered by a collective bargaining agreement, or is he not? Is he management, so he can't like grieve?
He's management.
Okay.
So the chain of command is chief, assistant chief, captain, lieutenant, sergeant, officer.
Okay. So he can't grieve the suspension.
No, he's not covered by a collective bargaining agreement.
Okay.
That's correct, Your Honor. And so in January of 20, he's issued the 3-day suspension, candidly for conduct unbecoming a captain. In February 28th of 2020, he makes his request for an accommodation. He testified that the request for an accommodation was to have coverage during his shift in case he had a flare-up of his condition. On that very same day, the assistant chief of the department said, no problem, we can accommodate that. And on the next business day, which was March 2nd of 2020, the unsuccessful chalk email, which is Appendix 95, is the accommodation that was granted on March 2 of 2020. He wasn't terminated until 10 months later. He was terminated on December 12th of 2020. So there's no temporal proximity between the request for a reasonable accommodation in February, and 10 months later, the termination in December. I'm not sure where my sister is getting this narrative that he was terminated 2 months after he requested the accommodation. That's simply not the case. Now,
There's a renewal request, right? There's a request for renewal that's granted.
Right, and so there are the FMLA requests. The first FMLA request for intermittent leave was made in October of 2019. In October of 20, he renewed that request. So the intermittent leave under the FMLA is he gets 12 weeks for 12 months that he can use intermittently, obviously. It's not continuous leave. And so he testified that he never used that. He testified he never used that. He said, essentially, I got it in case I needed it, but I never used it. Because just in case so if we construe FMLA as protected activity, which I don't, then he got the intermittent leave in October of 19, and it was renewed in October of 20. So to the extent there's temporal proximity, it's between October 20 and December 20. That maybe is the 2 months. However, what happened in that intervening time frame was that an alarm went off in the emergency control center, which is always under surveillance. Ms. Carew, Port Officer Carew, was working there because she had an accommodation for pregnancy, so she was doing light duty. The alarm goes off. The chief looks at the video and says, well, the alarm went off because PUOPOLO propped the door open. So they look at the video, PUOPOLO's in there having a meal with her. Now this is the heart of COVID, so all the social distancing, masking, no meals together rules were all in place. He's in there having a meal with her, chit-chatting, and she's an officer. He's captain, lieutenant, sergeant, officer, okay? Very inappropriate. And at the end of their conversation, he stands up and strokes her hair. And then they say, this is bizarre, and it shows up on video again later in October and November. So they talked to him in December of 2020 and say, you know, what's going on here? This is totally inappropriate, and they decide to terminate him. So even if you were to accept, construing in favor of the plaintiff, that the October 2020 FMLA leave request was protected activity, there were a lot of intervening circumstances that were legitimate, non-discriminatory, non-retaliatory reasons for the termination. First it was progressive discipline. He'd already been suspended for something else in January. And secondly, it was for these inappropriate actions towards his subordinate. I would just add, and we have it in a footnote in our brief, that I don't believe that an FMLA request is protected activity under Chapter 151B. Now, the FMLA, federal law, does have a retaliation provision. That was never pled in this case. The provision that I assume it would be, well, the words retaliation and protected activity don't appear in Chapter 151B. Chapter 151B, Section 4, parens 4, is what we call the opposition clause, so that if someone opposes activity governed by Chapter 151B, such as testifying or filing an MCAD charge, they have protection. In Chapter 151B4, parentheses 4A, is a clause that says if someone is exercising their rights under the chapter, they have protection. If someone is exercising their rights under the FMLA, just under a plain reading of the statute, they're not exercising their rights under 151B. So we would submit as a matter of law that filing a request for intermittent leave under the FMLA is not protected activity because it has nothing to do with 151B. Having said that, the Superior Court judge did reject, you know, that argument, and she did look at both the request for accommodation and the leaves, and concluded that because of the non-retaliatory reasons for the termination, there was no causal nexus between the termination and the leave requests.
So what do you say to the statement that an officer would then respond and assume command requires him to stay and wait till they respond?
Well, I would just read, and this is the March 2, 2020 email to Mr. PUOPOLO. It says we started the process ASAP. The response is that they are able to reasonably accommodate you leaving right away, and that you'd have to notify the sergeant and lieutenant that would be working the shift with you, and that you would be leaving, and they would be assuming control and command, full stop. So the first concept is, your job, Captain Popolo, is to notify the lieutenant or sergeant. They're assuming control and command.
So there's always two people working the desk.
Always a sergeant and lieutenant on shift. Captain Popolo testified to that, as did Chief Grady. You would also have to notify Chief Tehan and Chief Shishka that you are leaving. Chief Shishka would then respond and assume command. So there could be admittedly, some ambiguity in there about respond and assume command. I think, Justice Massing, your reading was right. The idea was they would respond and get over there and assume command to relieve the sergeant and lieutenant. But let's just assume, for, construing all facts in favor of the plaintiff, that there was confusion. As Justice Sachs pointed out, the whole law of accommodation and interactive process is meant to be flexible, because oftentimes an employer grants an accommodation that for one reason or the other doesn't work perfectly. And so certainly Popolo was within his rights to come forward to the department and say, hey, I'm confused. Do I have to wait around because I really can't based on my situation? I'd have to leave right away. Or, gee, this doesn't really work for me. He did none of that. He did none of that. And there's no evidence that he questioned this accommodation at all. What he did testify to in his deposition was that he was aware of the process. He had notified the lieutenant and sergeant. He said, yes, I'm aware of that. And then he said, but I never took advantage of that accommodation. So contrary to what my sister just said, he never exercised that accommodation. He did say in interrogatory answer number 19 and during his deposition that at one time he contacted, as Justice Allen pointed out, by email, text, and phone, Grady and Teagan one night asking for relief. However, that was not, well, first of all, Grady testified that never happened. Second, as you pointed out, there's no evidence of this text or email in the record. And third, the accommodation requires in the first place that he notify the sergeant or lieutenant. In the second place that he notify Shishka and Tehan. Grady's name does not appear in that March 2 email. Grady's the chief. He's not going to be involved in this kind of situation. So let's assume that Popolo did one night contact Grady, and Grady didn't get back to him until 4 hours later. He was not exercising the accommodation at that time, though. It may have been some random situation where he reached out to him and Grady didn't respond. But he testified that he never exercised the accommodation, and the fact that he may have reached out to Grady at some point is a much different situation than exercising the accommodation, which is to reach out to the sergeant and lieutenant first. So I think that even construing that fact in favor of the plaintiff, it doesn't make out a claim of disability discrimination.
Can I ask you a legal question? Can you consider pretext in the prima facie case?
Yes. So this is retaliation. In order to establish, no, Your Honor, you cannot. But let me. In order to make out the prima facie case, it's three parts: plaintiff engaged in protected activity, plaintiff experienced an adverse action, and number three, there's a causal nexus between the first two. I think it's the Saxena case versus UMass, if I recall correctly, makes it clear that that has to be the determinative factor, the determinative cause. In other words, the adverse action would not have happened but for the protected activity. That's why temporal proximity is important, obviously. In this case, there was no temporal proximity. But at any rate, where we get into the pretext is as follows. If the plaintiff is able to establish those three elements under the McDonnell-Douglas standard, we go to the second stage where the employer has the right to state the legitimate reasons for the action. Then we go to the third stage where the employee can say, no, that's pretext.
But suppose they could show that the being terminated for flicking a ponytail is disproportionate to the crime. So that wouldn't that then leave the inference that there's something else going on?
Well, respectfully, I don't think so, Your Honor. The flicking of the ponytail only resulted in a suspension, a 3-day suspension. And that was.
I thought that was part of the videos.
It was.
that came after.
I'm sorry. You are correct. I am wrong. The flicking of the ponytail, which happened on three occasions, at least that we have on video.
And masking and.
Did happen in that October 2020 timeframe. Pardon me for that. I think that it was a number of factors. As a matter of progressive discipline, he had already been suspended. He'd been put on notice, hey, you're not acting like a captain here. You're doing a lot of things that are creating a lot of dissension in the department. You're exercising favoritism towards this young woman. You know, she is 3 ranks below you. You're not acting like a captain. And then to see this on video, he was not forthcoming during the investigation. There were others in the force that came forward, it's in the record, that said, this is unbelievable, this is happening, you're allowing this to happen, this is disgraceful. And they felt they had had enough. So I don't think it was just the flicking. And also, as a captain, he was responsible for enforcing the policies that he was violating. He goes into a room, he props open a door, he sets off an alarm, he violates every COVID restriction that was in place. I don't care, I'm just going to do this because I feel like doing it. That's not how a captain is supposed to act. So I don't think the punishment was disproportionate to the situation that was presented. And finally, I'll just say, in terms of the disability claim, Massport did grant the reasonable accommodation. That should close that case. In terms of the retaliation claim, the judge did find no causal nexus. This idea of I had to wait or it wasn't convenient for me to call, that's all purely supposition. There's nothing in the record to support any of that. It's all argument.
Okay. I see no more questions. So again, thank you both. A very helpful argument.
Thank you, Your Honor.
And the case is submitted. We're going to hear one more before our customary 15-minute break for the mid-morning. And the fourth case then is 24P 1165, Shane Doe versus Mark Thorell and others.
Good morning.
Just a sec, please.
Sorry. May I, Your Honor?
Okay, thank you.
Good morning. May it please the Court, Howard Cooper for the Doe family. As Your Honors are aware, post-Bristol Asphalt v. Rochester bituminous, this Court's review of the trial court's decision on the Thorell's anti-SLAPP motion is de novo. And under the two-step analytical framework set up under Bristol Asphalt, which essentially returned us to the Duracraft framework, there are at least 4 independent reasons why this court and the trial court should have denied the special motion to dismiss. The first reason, Your Honors, is that the Thorells cannot carry their burden to prove that the Doe's complaint is based solely on protected petitioning activity. In particular, Your Honor, the trial court ignored, in focusing only on the Thorells' November 6, 2023 letter, the preceding communications alleged to be at issue in the complaint by the Thorells to parents in the class, communicating what we allege is defamatory statements that Doe Jr. had engaged in bullying, racism, and destructive behavior on a day-to-day basis.
Does your complaint allege that the pre-letter communications was defamatory?
It does.
It's
the same statements, Your Honor. It alleges that those statements as published by the Thorells were defamatory, not just in the letter, but also to the parents.
I don't see that in the complaint. I do see the letter attached to the complaint. Are you relying on the fact that the letter was attached, and so you're incorporating the facts asserted in the letter?
We are, Your Honor, and in particular, I would note that the PS in the letter, which we point to, talks about the November 6th communication defamatory statements, which of course we also have a civil rights claim here. I'm sorry.
Let's stay on this subject. Is there anything other than paragraph 18 of the complaint itself that refers to communications from the Thorells? And that refers to the lengthy communication to the district administration, et cetera, in other words, the letter.
Your Honor, I believe the defamation count does as well in alleging, as does the civil rights claim, in alleging that the Thorells engaged in a campaign to deprive Doe Jr. of his secured right to a public education in the least restrictive alternatives as a disabled child.
So suppose we construe the complaint as alleging directly that the Thorells previously expressed concerns to other parents. Then the PS says they then asked to be included on the email so they could express their support. Why is that not petitioning under the anti-SLAPP law? In other words, any statement reasonably likely to enlist public participation in an effort to affect consideration of the issue.
So I intended to address this secondly, Your Honor, but under the Global NAPS case, the answer is that none of this is petitioning. Under the Global NAPS case, the crucial characteristics of petitioning are that the party making the statement or submission is seeking redress of a grievance, and the party receiving the statement has the ability to grant redress or to
So you interpret the letter as asking only for the removal of the child from the classroom? And you say that none of the people who received the letter had the authority to grant that relief?
Not only do none of the people have the authority to grant that relief, but there's a specific mechanism that the Thorells didn't participate in.
Okay, that's your view, your interpretation of the relief requested, but for the petitioning, at which it seems to me there are some fairly open-ended statements in the letter talking about, are there consequences to be realized? Is there appropriate support for the teacher? What actions are you going to take so our children are safe and continue to learn appropriately? It doesn't seem to me like that's asking only for removal of the child from the classroom, if it's asking for that at all.
It's asking for a number of things, Your Honor, and it specifically references the code of discipline that was available to the Thorells if they wanted to make an actual complaint about the behavior in the classroom, which would had to have gone to Mr. Hawes, the principal, or his designee.
Okay, so to that extent, the letter does request relief that's within the power, at least of some of the recipients, to grant. Would you agree with that?
I don't agree, Your Honor, if I may explain. There are two potential routes here that the Thorells could have gone with regard to Doe's secure right to be in the classroom if he was a problem. One would have been to seek to influence the IEP process, which was already over by the time they sent their letter. The second would have been to
would they ever be involved, would other parents ever be involved in your client's kid's IEP process?
Not directly as participants, Your Honor, but to inform the school that should be taken into account.
But how would they even know that the school's considering an IEP?
Well, Your Honor, they actually put in their letter the least restrictive alternative language, so they clearly knew about it.
I mean, they guessed, right, that he'd been mainstreamed, but...
Well, I don't think it's a guess for them to say that almost explicitly that he'd been mainstreamed in a least restrictive alternative, and the Thorells in their affidavits concede that they're familiar with that process.
So let's say they knew somehow that an IEP team meeting had been held in the last week of October and had kind of reaffirmed the previous decision to mainstream, to put this child in Mr. DeMarco's classroom.
Yes, Your Honor.
Then an incident occurs on November 3rd after that IEP team determination. Is it not petitioning activity to send a letter to two members of the team, granted others, but at least two members of the team, saying, look at what happened recently. You need to reevaluate whether this is working?
Your Honor, that would be petitioning activity to the extent it expresses a grievance and it's directed to someone who could do something about it or not on an informed basis. But that's not what happened here.
Well, do you agree that the principal and the teacher are on the IEP team?
Yes.
Okay, and they were recipients of the letter?
No. In fact,
they were not recipients of
no, the letter was addressed, Your Honor, to the entire school committee who have nothing to do with any of this.
Were they included on the letter?
The copy of the letter that I have, Your Honor, does not show them being included, and rather it's addressed to the administration and school committee members.
Well, the email is copied to the email that transmits that letter is addressed to J. Hawes. It's CC'd to B. DeMarco. That's the principal and the teacher.
And that would be the principal and designee under the code of conduct if someone wanted to make a grievance.
Right, but they're also on the IEP team.
Yes, Your Honor, but the Thorells did not choose to tailor or tether their submission to the people who could give them redress for their grievance.
But they were over-inclusive.
They were over-inclusive by a lot, Your Honor. They broadcast.
I just want to get straight. You agree that this letter was sent to the principal and the teacher
I
who
do.
are on the IEP team. And so to the extent we construe the letter as requesting revisiting the IEP based on the events of November 3rd, that was relief that they had power to grant.
They did.
Okay.
But, Your Honor, the problem is the inclusion of the parents, the entire school committee, and the entire administration. And this is not a distinction without consequence, Your Honor. We're talking about a 10-year-old child whose IEP is supposed to be confidential, who has privacy rights here and has protected status. And what the Thorells did, and Mr. Thorell is actually a public employee in Hingham, what he did and his wife did was they broadcast what we say are the defamatory allegations about Doe engaging in daily brutality and being a menace and being racist, et cetera, to the entire school community, the entire administrative school committee, and the school and the administration. The school committee has absolutely nothing to do with this.
Okay, so the letter asks, we are asking not only for appropriate support for our son, but also for his teacher. Is a request for additional supports for the teacher not properly directed to the school committee? Do they have no power to affect that?
That's a request that would have normally gone to the principal, which it did. The school committee.
Well, but can't the school committee say, yeah, we need to put some more money into having aides in the classroom or giving training to teachers so that they can deal with kids with disabilities and allow them to be mainstreamed?
Yes.
Is that not something that would be plausible relief that the school committee could consider in response to this letter?
Not with regard to Doe's status of being entitled to be in the courtroom pursuant to his IEP in the American with Disabilities Act. The focus of this letter, and of course, any citizen can petition the school committee to spend more money on whether it's the football team or support for teachers, et cetera. But there was a carefully calibrated IEP plan which included support. That's why Mr. Hawes was actually.
And in fact, the IEP meeting, according to the Moore affidavit, I think, had decided that additional supports should be provided. Why is it impermissible for the parents, even if they knew about the IEP, to go to the school committee and say, we need additional supports for our teacher because of this disruptive situation in the classroom?
Well, Your Honor, I respectfully submit that the letter is its intent and its message is to remove Doe from the classroom. Any portion of the letter, and that in and of itself provides an additional or substantial basis to any alleged petitioning activity.
Is there any case saying that all of the requested relief in a letter that engages in petitioning, all of the requested relief must have an arguable basis in law?
Yes, Your Honor.
Every item of it? What's that?
Sabatini versus Knaus, and I was going to get to this, Your Honor, which is a decision that postdates Bristol Asphalt from this court in January of this year, and if I may explain, the case is indistinguishable. Dr. Knaus was an employee in a lab of Dr. Sabatini. She claimed she was being sexually harassed by Dr. Sabatini, as were other women in the lab. She first went to her colleagues in the lab to raise the issue of her alleged sexual harassment. The matter then was elevated up to the administration and then ultimately, because of the funding in the lab, to NIH, which is obviously a governmental entity. Dr. Sabatini brought a lawsuit claiming defamation, interference, and the like against Dr. Knaus, and there was a special motion to dismiss that was filed. This court said very clearly and unambiguously that it needed to parse the decision by Dr. Nuss to go to her colleagues, who were not mandatory reporters, but who clearly could have joined her, and she was asking them to join her and talk about sexual harassment. But the going to those colleagues was a private matter. It was not petitioning activity. That the petitioning activity did not kick in until there was communications with the NIH.
Right, but here we have one communication, setting aside the pre-letter conversations. We have one communication that's directed to government officials who may have some authority to grant relief, and your argument is that at least some of them did not. In Sabatini, there was a separate earlier correspondence with her colleagues, and that's, I think, what the court was focusing on. Here we've got one communication directed to a range of people.
Well, Your Honor, if you look at the PS, it's not clear that it's one communication. It looks like it may have been happening over time. The Thorells in their affidavits suggest that this had been going on for a couple of months. But more importantly, I want to come back with my 1 minute remaining to the Global Naps case, which I think is really dispositive on the second reason here that the special motion should have been denied. And that is that just as in Global Naps, there was an arbitration going on when Verizon's chief compliance officer, Mr. Conway, decided to make a media statement, not just to the arbitrators, but calling Global Naps's program for its consumers a scam. The court said that statement did not have to that audience, as opposed to the arbitrators, that statement did not have the crucial characteristic of petitioning because it was directed to people, in part, that couldn't address the grievance and provide relief. Very briefly, Your Honors,
Who are those people in this letter?
So the people in this letter who can't provide relief are the school administrators who got it, the other parents who got it, and the school committee. None of them could address how Doe was going to be supported in that classroom because they're not on the IEP committee, Your Honor. They are not part of the school disciplinary proceeding, which is the principal and the designee. So what happened here, and may I just provide one more remark? Your Honors, what happened here is that there's a 10-year-old boy with protected status in a classroom who has an episode on November 3rd. The principal is there, does not record in his version of events as an eyewitness that there was any problem with destruction or bullying or intimidation or racism. Instead, he says, I'm proud of Doe Jr. for what he did today. That's how the IEP is supposed to work. But what happened is some of the kids went home, said something to their parents about being out in the hallway, and the Thorells decided to take it upon themselves to launch a campaign, starting with the rest of the parents, communicating a defamatory statement that this had been a daily occurrence since the beginning of the school year, which was not true, and they have absolutely no personal knowledge of what went on in that school.
I want to ask you about the personal knowledge. You really emphasize that language from Bristol Asphalt.
Yes.
So you're saying that parents relating what their kids tell them, that's not good enough? Like, did they have to get affidavits from their kids?
Well, they could, respectfully, Your Honor, I recognize the sensitivity, and I don't mean to make light about it. Of course, they don't have to. They could have their kids be interviewed in the process, if properly initiated under the Code of Discipline, or some other route to try to influence the IEP process.
But I mean in terms of what you submit in affidavits to support an anti-SLAPP motion.
Yes, the SJC was clear in Bristol Asphalt that the statements in the affidavits must be based on personal knowledge, and these were not. These are complete hearsay. We offered a letter from a specialist therapist who talks about the unreliability of what kids talk about when they come home about what's going on in school. But I would also submit, Your Honor, the SJC identified clearly, and it's continued for the last 40 years, this statute's a conundrum. In protecting the defendant's petitioning rights, they're necessarily interfering with ours, but this case is so far afield from the narrow set of cases contemplated by the SJC having to do with a wealthy real estate developer suing people objecting to their project. There are secured rights here. So when Your Honor asks me about the personal knowledge required in the affidavit expressly by the SJC, if we're going to have this statute, there have to be clear-cut rules. And you can't rely on hearsay because you are...
Follow up on that. If a parent tells a police officer, my child tells me that the gym teacher touched her inappropriately, please do something about it. Is that, I mean, that's petitioning activity because it's directly to a police officer, but does it lack arguable factual basis because the parent has no personal knowledge and is relying on the child's report?
Well, I'd respectfully submit, Your Honor, that a parent's fresh complaint report to a police officer on behalf of a minor child does have an inherent investigatory basis, but in the context of an anti-SLAPP statute, if I had...
Well, but it's not, is that based on personal knowledge, or is that, does that request to the police officer not constitute an arguable factual basis?
Police officers rely on hearsay reports 24/7, Your Honor.
Right.
But we are in this situation now where someone is
They
trying...
didn't say hearsay, did they?
I'm sorry?
The SJC didn't say hearsay. They said not based on personal knowledge. The parents, in my hypothetical and in this case, have knowledge of what their children told them, and they're asking the recipients of their petitioning to do something about that.
But, Your Honor, you need to go back to what was actually said and to whom, and what was said is that on a daily basis, Doe is bullying, intimidating, destroying property, and making racist remarks, which is not true. And not true at all, was defamatory, and it was not directed towards making a police report, and that issue has not arisen, the hypothetical, Your Honor, respectfully, doesn't arise in the context of someone trying to seek legal redress. Doe and his family are trying to seek legal redress for the interference with a secured right here, namely to a public education in the least restrictive alternative. That's what's at issue in this case. This is not a matter of hearsay or lack of personal knowledge facts necessary for a police officer to have reasonable suspicion to launch an investigation into a complaint of improper touching. I think those two contexts
Okay,
are distinct.
thank you for the answers, and we'll hear from the other side.
Thank you.
Thank you, Your Honors. May it please the Court, Patrick Ulrich for the defendants' appellees, Mark and Abby Thorell. I'll just start with addressing the plaintiff's arguments rather than rehashing what's been in the briefs, and specifically as to the first issue that was addressed as to whether or not the particular postscript in the letter, which says, after expressing our concern to them, the other parents, and indicating that we were writing a letter, they asked to be included on the email to express their support. The plaintiffs assert that this is not petitioning activity. I think that is an incorrect assertion for several reasons, Your Honor. Setting aside even the fact that this is not, I think a fair reading of their complaint does not include any allegation related to this in the first instance. It's really about the letter. This is a response to this is a pivot in response to the special motion to dismiss. One, as Your Honors correctly pointed out earlier, the text, the 5 enumerated points of what constitutes petitioning activity under the statute. This is enumerated with them. It's an encouragement of participation in submitting a petition to a government body. I would say, too, that is exactly, in terms of what we can look to, that is exactly what happened. The letter was sent to the school committee, the superintendent, the teacher, and the principal, as well as 4 other groups of parents. As indicated in the postscript, the Thorells indicated that they were sending this letter. Those people wanted to be included. They did, in fact, themselves make petitions of their own to these same individuals. The McDonald family submitted an email and a letter as well. So as evidenced by the the objective indicia of what this ultimately accomplished was more petitioning activity.
How many parents, how many there are 4 other parents CC'd?
Yes, Your Honor.
And how many of them followed up like the McDonald's did?
I think
the McDonald's did. I'm not certain, there may be in the record, I'm not certain if it is or not, that in the response from the superintendent to all of the parents, that there may have been direct communications back and forth following that between the superintendent. I'm not certain if that's in the record or not, but I know that that's what happened. But at least what's in the record for certain, it's the McDonald family. I'm not certain if there were others, Your Honor.
Is there some sort of school handbook that lays out a procedure for this type of complaint or interest? And if yes, did they follow it? Or did they go beyond that?
I would say no, Your Honor. There isn't something that specifically addresses this issue, but I would certainly also say that there is no singular way. There's nothing anywhere that says the only way you can address disruptions, unsafe behavior in a classroom as a parent is that you have one person you can go to. That hasn't been presented by the plaintiffs, and I'm not aware of anything else. So the idea, their assertion is that the Thorells should have gone to the IEP team. The Thorells didn't even know who those individuals were, or that the son was actually on an IEP. But even if they did, regardless of that, it does not prohibit, it does not presume that they could not also reach out to the school committee and the superintendent. And we cite the sort of statutory relationship between the superintendent having authority in hiring, or the school committee having authority of hiring and, creating policies for the superintendent is responsible for, the superintendent's responsible for implementing them, and obviously the superintendent then oversees the principal and the individual teacher. Yes,
suppose a letter is directed to public officials who have some power to grant relief on the issue that the letter discusses, but it's also directed to public officials who have nothing to do with it, and or members of the public who would have no particular interest in or be likely to weigh in on the issue. Is to that extent, to the extent it's directed to those other groups, is it still petitioning activity?
I would say so. I mean, you could imagine, Your Honor, we're here today before you, talking to you, and there are others in this room that are not actually participating in making a decision about how to ultimately decide this case, and this is petitioning activity. If the Thorells had stood up at the school committee and said something, there could be others in the room as well that would ultimately hear it. But I think
I guess I'm asking, is there case law that tells us whether, this letter sent to the school committee, that wasn't merely incidental to a communication to the teacher and the principal. They were directly addressed.
Right. So I think, yes.
Where you would have a single communication that's directly addressed both to officials who can grant relief and officials who can't, or to others, private citizens.
Well, I'm not certain, Your Honor, that there's like a precise set of facts as the one before this court. But I think, in terms of what what courts have examined before, we have the McDonnell v. Patton case where statements have been made in an online forum, and those are ultimately determined to be petitioning activity. I would, in the Office 1 v. Lopez matter, Your Honor, that involved a situation with condominium owners who held condominium meetings and shared communications with others to say, hey, we want you to submit letters to congresspeople or to whomever. Those instances there were also determined to be petitioning activity. So I think in that instance where just because there are the communication in, for example, Office 1, petitioning activity wasn't just the later petition to a government body, it also included the individual communications among the unit owners that also was petitioning activity.
But I guess I'm asking about communications to a government official who has no authority to grant relief, not even arguable authority. I mean, I understand that there's a dispute about that here, but suppose that this letter had also been sent to the Director of Public Works in a neighboring town. Clearly, someone who doesn't have power to grant relief and is not reasonably expected to be enlisted in the Thorell's petitioning.
I would say that would still be petitioning activity. I don't think the copying of another individual on it is going to defeat the petitioning activity itself, Your Honor.
Wouldn't that allow someone who wants to broadcast a message, perhaps a very negative message about another individual, to shield it from any defamation or similar claims simply by copying someone who has power to grant relief on it?
I guess again, I would always revert back to when you're examining a hypothetical to the Bristol asphalt analysis, is whether or not it's petitioning activity, and then the question of whether or not there is a reasonable factual basis for that petitioning activity or an arguable basis in law. And I wanted to point out too, Your Honor, that the standard, when we're asking sort of like what's the hook for that second step, because I think that's really ultimately a question about the second step. Like it's petitioning activity, now is there any arguable basis in law? And what the Wagner court says is that the non-movement, the plaintiffs here, have to show that the petitioning was not that it was based on an error of law. So even if the Thorells were totally incorrect in saying, oh, we reached out to the school committee and the school committee didn't have any basis to grant any type of relief for them, what the SJC says is that the plaintiffs here must show that no reasonable person could conclude that there was a basis in law for the petitioning activity. So the question is, before this court, is whether or not there's no reasonable basis for the Thorells at all to have concluded that reaching out to the school committee, the superintendent, and the teachers, that was not the appropriate place to voice that. And I think in your hypothetical, Your Honor, the facts would bear out that that was not legitimate petitioning activity because somebody was reaching out to others when no reasonable person would actually do so. So I think it's less about the question on the first point of whether or not it's petitioning activity. It's more about the second prong as to whether or not there's an arguable basis.
I have a parallel question. I mean, the power to grant relief goes to the issue of arguable basis in law. I have a parallel question on the reasonable factual basis. Is there any case bearing on whether every factual statement in a petition or a letter like this must have some reasonable factual support? Or do we look at the letter as a whole?
I think you look at the letter as a whole, Your Honor, and I think...
Is there a case that says that?
I think it's sort of implicit in the idea of Bristol Asphalt itself, which is to say, and what Duracraft says, which is this is not an examination of the underlying claims themselves. The standard is whether or not there was any, whether or not the plaintiffs have been able to show that there was no reasonable factual basis. And I do not read any of them as saying that each and every exaggeration as asserted or characterization that the plaintiffs would make of the facts that have been asserted in the letter have to be shown to have not lacked a reasonable basis. So no, I don't think that type of individualized parsing is there. I would say that in this, to address that question, Your Honor, which I was going to get to about whether or not the court can consider the affidavit that were submitted by the Thorells and by the other parents, is that that assertion by the plaintiffs ignores the fact that there is the email from the teacher himself, which identifies that there were disruptions in the classroom, that people were removed and taken out of it. The response from the principal, which says we are acknowledging that there have been disruptions. The complaint itself admits to dysregulation in the classroom. So even setting aside the Thorells' affidavit itself, there is sufficient evidence in the record to demonstrate that there was a reasonable factual basis undergirding their petition. I would also say, Your Honor, as indicated in our brief, that the Thorells, as you addressed in the hypothetical, the Thorells have knowledge of what their child told them happened in the classroom, and it seems an odd thing to think that a parent could never speak up about what was going on in their classroom because they're not actually physically there. And I think the section of Mass Evidence 822, which talks about that at the very least, the affidavits are admissible to show that they had notice of what their children said and what their children told them was going on in the classroom. I think that is a reasonable basis, factual basis for them to then submit their petition as well.
And do we look at whether it's reasonable to rely on the reporters who told the parents what's going on? I mean, it might be reasonable in this case, but you can imagine a situation where kids come home from school and report something that went on in school, and due to the age of the kids and the nature of what's reported, it's not very plausible.
I think that...
the men from Mars landed at the school today, and the principal shot a ray gun at them and blew up their spaceship. I'll
concede that, Your Honor. I don't think that's a reasonable basis.
Okay, so we don't allow reliance on the reports of others, no matter who they are and what they say. There's some reasonableness requirement there.
I think that's fair, yes, Your Honor.
You may have answered this already in response to one of Justice Sachs's questions, but what would the impact be if the letter was a response to the letter from the teacher regarding, because I think the letter was sent, was it on the 6th of November? And the
Correct.
Major incident was November
3rd.
If it had, instead of being a standalone letter, if it had been a reply to that email with some CCs, and maybe this would have been a better question for your brother counsel, but.
I think that would still be petitioning activity. I think that would fall squarely. I don't think it would change it materially, whether it was a response or a reply or not. And lastly, Your Honor, on the issue of the question about the admissibility of the Thorell's affidavits and whether or not there is sufficient evidence, the statute does provide for the ability to have special specified discovery. In response to the argument that there was, that the Thorell's affidavit was inadmissible and should not be part of the record, we did before the lower court. The lower court never actually decided upon it. We had submitted interrogatories to which and requests for production documents, rather, to the plaintiffs, which they refused to respond to, because in the complaint itself, they say, we have communications and evidence demonstrating the dysregulation that's been happening in this, in the school. And what we said is, then you should provide them, and those could be part of the record to further, support the basis of this. And that was never decided. The statute contemplates it. I'm not asking for it here necessarily, but only in the event that the court were somehow to decide that there was no reasonable factual basis for the petition, that's another avenue, that there is evidence in the plaintiff's hands as to the determination about bullying, the communications from the teachers and the principal to the does about what actually happened in the classroom.
Can I just ask you, and this relates to whether there's an arguable basis in law. They argue that this is the IEP there's a strong mandate to have mainstreaming if possible, and they'd already made that decision. And when there's an IEP for a child who has dysregulation issues, there's always going to be, it's never going to be a smooth sailing in the classroom. Is there a reasonable basis in law to petition, in these circumstances?
I think so, Your Honor. The dysregulation that happens in the classroom impacts the other students that are there, the other sons and daughters that are physically there. They have rights as well, as do their parents, and those parents have concern as to, how much time and effort is being committed to their children's education and whether or not it's actually being focused to one individual person and their behavior in the classroom, and whether or not that it's an unsafe environment that the children are being exposed to in terms of the language and the physical activity. So I think the parents have an interest, a right into their own children's education. The context of all this is it took place in a public school classroom with public school teachers. This is a classic example. The reason for the existence of this case is because the Thorells have an interest in their own child's education, and everyone who was involved from the beginning to the end were, public government executive individuals.
Okay, well, again, thank you both. I mean, I think you'd be both excellent advocates for your clients.
Thank you, Your Honor.
Case is submitted, and we're going to take a 15-minute recess. Thank you. We're back on the record for 24P 1375 DCF versus, my thing says mother, but it's really father. And I don't have to remind you, but this is an impounded case, so it's referred to mother, father, daughter, son, no names. Thank you. Floor is yours.
Shall I wait for the green
Oh,
light?
yeah, you're waiting for the, go ahead. When you start, it'll
Sure.
start.
Good morning, Your Honors. May it please the Court. I'm Jennifer DeFeo. I represent the appellant father who is here in the court with us today. We are asking that this court, perhaps he hasn't come back in, he is here. We are asking that this court vacate the termination of his parental rights and to remand this case for further hearing. The juvenile court judge focused on three primary factors: substance use, codependency, and domestic violence. I'd like to focus on the codependency aspect first. And the reason why is it really presents some fundamental unfairness in this case. DCF controlled the who, when, and where of everything in this case. They controlled when mother and father saw the son. They controlled when mother and father saw the daughter. They controlled when they saw the siblings together. They controlled who was present at the home visits. They controlled when they happened. But yet the judge found that they were so enmeshed that there was an issue. DCF relied on a case, Adoption of Larry. And I think that case actually shows to us some of the clear errors that happened in this particular case. For one, that revolved around a shaken baby. The parties were married. And there was a lot of dialogue in that case between mother and the court investigator, mother and DCF, about what would mother do to protect this child from father going forward. So the question we have is, what would this father do going forward to protect child from mother? But I ask you, what is the real issue here? What was he having to protect her from?
But wasn't it within the discretion of the judge to credit the workers and the documents that that the parents were not forthcoming, that they were, I mean, the thrust of it seems to be that the department believed that the parents were essentially in collusion to put the primary blame on the mother for the actions, that she was not going to be able to be successful, and that they would sort of, she would take the blame for many things, and that father would present as less culpable in a lot of the actions. And why was it not within the judge's discretion just to credit the workers that they didn't believe that in combination with the fact that they actually did not terminate their relationship for months and months and months until right on the eve of trial?
So I do want to address that in pieces, Your Honor. So the last home visit that was conducted by DCF of the parents was in October, the month before trial. There was no home visit in November, December, or January, not because of anything the parents did, but because of DCF's own inaction. So when the trial happened, the parties said, we are not together. There's nothing to suggest that there were, other than Dad gave Mom some rides to court. They did see each other. They had a cat in common. So we're not looking at something that they're still totally enmeshed as they had been in the past. Father, through therapy, realized, okay, this is not good for me. This is not good for my child going forward. I am going to make the steps to break the pattern of codependency that exists. In this case, Your Honors, the thing that we need to look at is what was the actual neglect that happened? What was preventing these parents from providing the minimally acceptable care? What happened was there was a very significant allegation incident of domestic violence in 2021 that caused the removal of the daughter. Since that time, there has been no other domestic violence incidents. In 2022, when the son was born, there was a mandatory 51A filed by the hospital because he was a substance exposed newborn. Today, Your Honors, if that had happened, had this child been born today, under Governor Healey's new rules, under Mass General's new policies, unless there were other factors existing, they would have even filed a 51A because there was nothing to show imminent harm to this child other than his substance exposure. So from 2021 to 2022, when the son was born, these parents struggled. There is no doubt about that. But they went into detox. The detox for Dad was a changing point in his life. He began to say, okay, I need to focus, I need to get my life together, I need to be more consistent in my visits. So what was the burden that was preventing them from providing minimally acceptable care? The domestic violence?
So he went into the facility for detox, I think, at the same time, in January of 2023 or 2?
It was 2022, so it was before the
2022.
child was born.
Right. And they knew that the mother was pregnant. He testified that they knew at that point that the mother, they just found out, or within weeks, a little hazy, but there was testimony that they knew that the mother was pregnant with the child at that point. They didn't separate for another 18 months.
No one ever told them to separate, Your Honor. And that's the thing.
But it's not, but I don't, but why is being told the important issue? If that was the defining moment where he needed to make his life better for this child, did he not realize that at that point, for another 18 months, that the mother was the issue? Because I think that would be a problem.
The codependency took time to break. When you look at mother's substance abuse, where is the nexus between her substance use and her inability to provide minimally acceptable care? There's nothing in the findings that said mother was passed out next to daughter. There's nothing that says that. Mother and father developed a problem after the removal of the daughter. So their prior substance abuse issue wasn't really the contention that caused the removal. They went through a very, very bad period when their daughter was removed. When they found out mom was pregnant, they said, okay, we need to get this together. They got it together. Dad proved his sobriety. If you look at the records, even if you only take from April of 2023 to the time of the last day of trial, you're looking at a substantial period in which not a single blip on insurance. He signed unlimited releases. DCF got these records directly. DCF said to mom, we want a supervised screen. They never said to father, we want a supervised screen. If they were concerned about his sobriety, why didn't they do that? But again, mother had a substance abuse problem. There are blips in hers, definitely. She tested positive several times. But again, it's required that there be a nexus between her substance use disorder and her inability to provide minimally acceptable care. It's not there. She was not neglecting to feed the child. There was an issue that the child was underweight. Mother's a very petite person. There's issues that during COVID.
Did she ever have custody of the child, of the son?
No, he was removed from the hospital because of the mandatory requirement to file 51As when a child is substance exposed at birth. There was nothing else that mandated that hospital to file a 51A with the exception of the substance use. They did not say.
But I thought you were suggesting that she took fine care of the son when actually she never had of the daughter.
My apologies if I wasn't clear enough. So the issue for removal on the daughter did not have to do with substance abuse. It did not have to do with her criminal record or anything like that. What it had to do was there was a horrible incident between father and mother. Yes, father downplayed it, but what you look at in this situation is, what did his collateral say? The ongoing social worker who testified at trial, who was the only person who could provide any testimony as to current fitness or to provide testimony as to father's potential unfitness to the indefinite future to a near servitude, was the ongoing social worker. And you know what that man said? He said the collaterals are pleased with this man. They found him cooperative. They found him to be able to help his peers in these groups. They found that he had improved in his timeliness to visits, in his appearance at visits. And you know what's important? When we look at the substance abuse issues of either parent, not once during any visit did DCF say, these parents appear under the influence. Never once did they say, these parents smell like marijuana during a visit. Never once did they stop a visit early. And as a matter of fact, the social worker said, I never saw or see anything in any record that suggests that these parents had aggression towards each other, verbally or physically. Why? Because prior to father being sober, prior to him engaging in lots of services, there were issues. There were definitely issues. But he progressed. And that's what this court should have looked at. They should have looked at his improvements. Because
I'm sorry to interrupt, but the judge said she didn't give much, if any, weight to the testimony of the ongoing social worker because he'd only been on the case for 60 days or so. Is that a permissible determination?
Sure, and if he didn't have the ability to testify as to the current fitness or unfitness, how can she be found, how can this judge find him unfit if there's no current testimony? There's nothing. So you can't discredit the only person who can say, these people are unfit today, into a definite certitude into the future and say, okay, we don't believe him.
And you look at DCF records from before this social worker came on the case?
You can, but when was the last report? And that's the key. There had been no home visit after October. The visits leading up to the trial were productive. They were on time. They were not missing them. Dad was employed. His urine screens were clean. This is all on the records. But I think the one part of the ongoing social worker's testimony that can't be discredited, he said, I spoke to the collaterals. I looked at the records, the collaterals, the drug screening, the anger management, the group therapies, they were all pleased with him. How do you turn around and say, as a judge, oh, I'm not going to accept any of those collateral responses because the man who's saying that this guy has done what he's supposed to do has only been on it for 60 days? Any social worker who sits in that spot to testify has to rely on reports. They're not going on just what happened at that exact moment. They can't. So when the ongoing social worker said, I have reviewed the reports, no, I am not versed on every little thing, but I am versed. I can tell you that Dad has made progress. He improved his timeliness, his ability to show up, his collaterals are happy. And I don't want to keep saying the same thing, but that is the key. This man who testified as the ongoing social worker was the only testifying witness who could testify as to current
I think
fitness.
under that theory, though, and any parent who was able to, maintain sobriety for a short period of time would never. We would never have you would never have the trials. There would never be findings of unfitness. If somebody for 30 days or for 45 days was able to, detach from a relationship that was poor, was able to maintain sobriety for a short period of time. And I think it's well known that takes a long time to truly get sober. Didn't the judge properly look at a long period of time and what had happened and had not happened over that long period of time?
So there's two things on that, Your Honor. First, I chose to use the April 2023 date as his sobriety date because that's when DCF had unlimited releases to obtain the screens directly. Prior to that, his most recent positive was for his Suboxone and THC in, I apologize, I think it was November of 2022. I'm drawing a blank if it was October or November of 2022. I'm sure I have it here in my notes. So we're actually looking at a much greater period of clean screens. However, DCF and the judge said, well, we're not happy that Dad provided us these screens directly. We want to get them directly. And they did. So that's why I chose the April 2023 date, which was 9 months. But if you look at when his last dirty screen was, it was a year plus before the trial. So it's not really this tiny, tiny short-term 30 days. At minimum, we're looking at 9 months. So what is the purpose of helping parents get sober if you're not giving the credit for their movement towards sobriety? This man proved 9 months of clean urine. DCF never said, we want all these, we want supervised screens. They had the absolute right to do so. They did it for Mother. If they were concerned about the legitimacy of these screens, Why didn't they do something else? This is their burden, Your Honor. This is not his burden to say, hey, look, I've provided all these screens. He's in a program that provides him Suboxone. The program monitors him. The program is not going to allow him to take home his Suboxone if they have any question as to his sobriety. The judge herself acknowledges that, for mother anyways. She says, well, you know, she needs at least 3 months clean to take home her own stuff. She was on methadone. Dad had Suboxone. He was taking them home. There was no question about that. There was a question about, well, was he taking the exact dose he was supposed to? And I do see my time is up, so I can either finish, or if there's no further questions, I can rest.
So I have one question, because
Yes.
something that you didn't spend a lot of time on in your brief that I do think is important is the fact that he had a criminal charge during the time of the trial that was significant, and was that fair for the judge to consider that?
So you can always consider criminal records as prognostic value as to conduct fitness. In this particular case, what you have to look at, it wasn't even on his carry. There was nothing before the court that said, these are the exact charges before the court. All of the charges, with the exception of perhaps the reckless destruction of property, which would have been a value-based, were misdemeanors. They were not felonies. So where is the substantial risk? He had a $500 bail. So this is not someone who was facing a dangerousness hearing.
But it wasn't, it was driving 65 miles an hour in a school zone where there were children. I don't think that was lost on the trial judge.
It wasn't a school zone. It was near a school, but the school was far enough away that it wasn't a school zone. And there was nothing that clocked him. The police officer said, I estimated, I think. No one was in the crosswalk, no one was injured. Was it a mistake? Was it something that would have been great had we known the outcome of it in this record? What we have are allegations. We have misdemeanor allegations of driving infractions. We do not have a man who was charged with hurting a child or anything like that. These are motor vehicle things. Yes, it was a long list, but it was uninsured, unregistered. Yes. Should he have taken care of those things? Yes. But he is doing all these classes. He's paying for group therapy, individual therapy. He's working. He's paying rent. This is not a man who's homeless, who's, he's stable employment. But there's only so much one person can do for those civil infractions. And you know what? I think that it's important to note, why didn't DCF provide an updated carry during the trial that lasted November, December, January, 3 months post those allegations? Why not? Why wasn't that brought up? And I think that's an important question, because we don't know what the resolution was in the record. If there are no further questions, I will rest on my brief. Thank you.
Thank you. Morning. Afternoon.
Members of the panel, may it please the court, I'm Kristen Braithwaite, Assistant General Counsel for the Department of Children and Families, and I'm here today asking you to affirm the decree issued by the lower court terminating Father's parental rights. Father is a profoundly violent man, a violence often directed at family and that has left Mother bruised, bloodied, hit, strangled, and fleeing from him on multiple occasions, and often in the presence of their older child. Father has an extensive history of substance misuse with an admitted years-long opiate dependency, and though his story has changed throughout the care and protection, he is admitted to using crack, fentanyl, cocaine, and marijuana.
If I'm just going to interrupt you. Could you focus on the codependence issue and your position on whether or not there was enough in the record for the trial court to find that there was enough for Father to be found unfit when a lot of the record focused on Mother and her shortcomings?
I can. At core to much of the court's concern was Father's repeated lack of transparency and ongoing misrepresentations about the entanglement he had with Mother, as well as about his own role in various instances. And so I think in addressing the codependency, the court was very concerned that it didn't have the ability to even assess what was true because Father was so incredible, and the court found that. Father and mother testified at trial that they had just terminated their relationship, but in the days before that, mother had testified, I believe, that there were various dates that they had broken up, and at one point she testified that they were still together. Not testified, I apologize, reported to the department in September that they were still together. Father told the foster care review team in August, which was 2 months before trial, that mother was his fiance. And then with regards to the details that the court had before it in the record, following the alleged termination of the relationship, which admittedly the date changed, those details included that father continued to provide transportation for mother, that mother continued to sleep at father's house, that mother's cat continued to reside at father's house, that mother's alleged address was questionable. She had indicated she was in Fall River. She would not provide any information about an address. She also at one point indicated that she would be going to Taunton. She did not change her services to reflect her alleged moving. Father reported that he spent many evenings with mother.
I ask, obviously, the judge's concern here was father's continued enmeshment with mother. Did DCF at any point in the case suggest to the father, you know, your continuing relationship with the mother is trouble and is going to make it difficult for you to regain custody? You need to think about that.
Father's action plan certainly involved tasks designed towards therapeutically working on how to be separate. And in fact, father even testified that in engaging in the services that he was asked to by the department, what he had learned was that it was better.
But I'm asking whether the services by the department or any communication from the department put the father on notice, to put it starkly, that he might have to choose between his relationship with the mother and his relationship with the son.
I believe that what father was put on notice about was that if they were going to co-parent, it would need to be without the domestic violence. It would need to be in a healthy way. And so I could certainly submit a letter. I don't offhand have the ability to point to a site where they did say, you're on notice that you have to terminate the relationship, but they certainly were on notice that the nature of the relationship would not be okay to reunify a child to. The domestic violence was significant and was, even before the child was removed, father was asked to engage in domestic violence treatment. He declined. Father was asked to engage in therapy. He declined. And so I think that the department knew that father and mother intended to co-parent. They communicated their intent to co-parent. And so the way that the department handles such a communication from parents is to work to figure out, well, how can we help you co-parent healthfully? So it isn't really common for a department to say, you must end a relationship, to parents who say, we're holding ourselves out as a unified couple. Instead, the department works to fix the errors or the shortcomings.
But it seems to me in other cases involving domestic violence in particular, the department will often say to the mother who is the victim of domestic violence, you need to get the father out of your life, because it's obvious that as long as he's in your life, you're going to continue being the victim of and exposing the child to domestic violence. So if this was going to become a major issue at trial, the father's continuing involvement with the mother, did DCF have some obligation to put the father on notice of that?
Well, DCF had an obligation to support father in where father was. I mean, I think that to say you have to separate could have been something that the department could consider doing. I mean, it was tricky, right? Because when you have parents that say we want to parent together, your goal is to stabilize. The department works to stabilize a family. Father wasn't just tasked with domestic violence, he was tasked with anger management. You know, there was a lot raised in appellant's brief about the fact that parents were offered the opportunity to have visits together, but this provides an opportunity to be assessed and to figure out how can we support you in working together. And so if this panel were to find that the department should have but did not ask the parents to separate, I would argue that that certainly doesn't render the decree invalid and would not require remand, because the department worked incredibly hard over 18 months to help the parents become healthy. And part of the challenge, as is repeated again and again in the court's findings, and as the record clearly demonstrates, is that the parents were not forthright about what had gone on before them. And so it wasn't easy to work with these parents. They would say to the police, oh, this domestic violence occurred. Then they would say to the department,
You know,
it was a
when was the
misunderstanding.
date of, when was the goal changed for the child?
I do not know when the subject child's goal was changed.
Maybe counsel for the child can answer that.
My apologies.
How about, do you disagree with the assertion in the father's brief that after the domestic violence incident of August 21, when the daughter was removed, she says there was no further incidents except for one verbal argument?
I do not. The court did not either. There was an incident in May of 2023 which father challenges as sort of unfounded that the court would make the conclusion it did. The police had to be present. The testimony was that the police didn't come. It was just a verbal altercation. And the problem here, as I know I've already indicated, is that parents' refusal to be forthcoming made it nearly impossible for them to be assessed honestly. And I would point the panel, I know I'm out of time, I would just like to point the panel to adoption of Flavia and adoption of Paula, because they speak to the fact that the lack of transparency is relevant to a court's assessment in determining whether there's fitness with regards to issues put before the court. There was a demonstrated history of severe domestic violence. There was a demonstrated history of substance misuse. There was no credible evidence that father had overcome either of those things. I do recognize I'm out of time.
Okay. Thank you. We'll hear from
Thank you very
John.
much.
Actually, counsel for the child, not really. Right.
Good morning, and may it please the court. My name is Molly Odie, and I represent the appellee child.
Do you know when the goal change was?
It was December of 2022. And the goal changed because after the removal of the child, between that point and December 2022, the parents were not demonstrating compliance with their action plan. At that point, they weren't participating in the services that were asked of them to the extent that DCF was expecting. And so really the parents just started working on their services, kind of following that point. And I want to speak to this question about progress, because I think that this is something that my sister focused on a lot, but mere participation in services does not mean that the fundamental issues that led to the removal of the child have been resolved. Just participating, being helpful and participatory in a class does not suggest that the parent has ameliorated their parenting deficits. And I think in this case, the judge was very concerned that because of the father's lack of insight, his lack of honesty, that he had not made really any substantial progress towards solving these issues of domestic violence that were very rampant and destructive in his relationship. And as a result of that, that led to concerns that if he's going to remain in this relationship with a mother, there is evidence that the incident in May 2023 was a domestic violence incident. The mother had scratches on her face, or the father had scratches on his face after that incident. And there's actually evidence from his therapist that she felt like in discussing this incident with him that he was minimizing the domestic violence in their relationship. So it's, I think, fair to say that there was ongoing violence happening since 2021. At the very least, the parents weren't being transparent with DCF about what was going on. I believe that the DCF worker found out about that incident not because the parents told them about it. That I don't think the parents disclosed that the police had been called to their home, but I think it was the worker receiving a police report found out about that incident. So that is just, it kind of exemplifies the ongoing lack of transparency that father had with, the court, with the workers throughout this case. I also want to address a few other comments made by my sister. One was about the October 2023 incident. And I think that the issue with this particular criminal incident, it's obviously concerning to have the father have charges that, one of them I believe was a felony charge. But I think what's more concerning about this particular incident is that the court found that father lied on the stand about his role in this incident after hearing from the police officer who was present and who arrested him. And so that, again, just points to his poor judgment, that points to his inability to take ownership of his actions and his willingness to be deceptive, even while sworn on the stand at trial. His dishonesty in that instance, is par for the course with his dishonesty throughout the case, and I think, frankly, it was reasonable for the court to question whether his progress was as good as it sounded because of that dishonesty about these many other incidents. At its core, I believe that this case is one about the role of the trial judge and the credibility determinations that the trial judge is allowed to make. The trial judge had the benefit of hearing the testimony of both of these parents and being able to compare that testimony to all the evidence in the record that included police reports, that included interviews with multiple DCF workers, a court investigator, and to see, okay, again and again, the parents keep saying something different, maybe 3-4 different times. So in this case, the trial judge's findings were overwhelmingly supported by the evidence and a reasonable interpretation of the evidence, reasonable credibility determinations. And I believe that all of that together gives clear and convincing evidence of father's unfitness, and that fitness was looked to be kind of indefinite. It wasn't that he was making such progress that he could improve immediately. He wasn't fit at the time of trial, and his ongoing relationship with the mother, which had not been, had not made a lot of progress, suggested that he would not be fit in the near future. So because of that, I think this court gives deference to the trial judge's assessment of the credibility of these parents and should thus uphold the lower court's judgment.
Can I ask you, you were not counsel at the trial, right?
No.
So, the father points out that that the counsel for your predecessor advocated for permanent custody, but not termination. What's the reason for the change?
So, Your Honor, this is a young child. He's 3 years old as of right now, and so the position is determined by substituted judgment, and that's assessed based off of circumstances that, at the time.
Which, if I'm understanding right, means your judgment essentially is different than trial counsel's. Not that there's anything wrong with that. I'm just asking if that's what I'm.
The judgment at the time is different from the position at trial. That's correct. Yeah.
Okay. All right. Seeing no more questions, thank you all for your arguments. Thank you for being here, and we'll take that one under advisement. And last one for today, 25P 167, Chelmsford Wood Residences versus Melendez.
You just need a moment to set up.
Yeah, take your time. And Attorney Curran's been here all morning long, so finally you get to go last.
I'll be as exciting as the last case. Tell me.
Not enough room, but you'll never be able to look at all that stuff anyway during arguments. So.
What was that?
You'll never be able to look at all that stuff while you're arguing. But
No, I
ahead.
understand. I'm just for the sake of the PDF piece. Thank you.
Good to have it there just in case.
It is.
Okay.
Yes, excellent. Good morning, Your Honors, and if it may please the Court, I am Attorney Dara Sandow for the appellant, Jennifer Melendez. And the reason that we're here today, it's quite an anomaly. I do a lot of work in the Housing Court. This case has already been before a single justice panel previous to this particular filing. It was initially brought forward on a stay of execution on a nunc-pro-tunc agreement that had been entered into between my client and the landlord, in this case, purportedly. And the agreement that was entered into was an otherwise unenforceable agreement on a number of fronts. The first issue I'm going to dive into is one of my primary issues on standing. This case initiated with a pro se litigant that had entered into an agreement to agree not to violate any of her lease provisions, agreed that on provision number 1 that the plaintiff was in part the landlord, and then in the event that she didn't violate any of the terms or conditions over 4 months that come, I believe it was 3/31/2023, that the case would be dismissed. The issue that is here for standing is that the landlord is not Chelmsford Woods Residences LP2. The actual owner of the property is C.W. Woods underneath.
Well, they were on the original lease, right?
They were not on the original, sorry, Chelmsford Wood Residences LP2 was on the original lease. Yes, you are correct, Your Honor.
And at the time of the agreement, was that the underlying lease?
Sorry,
At the time of the agreement that you say was invalid, was that, it was the correct landlord?
That was not.
It is a lease renewal that the name changed.
It is correct. So at the time that the violation was alleged to have occurred, which, by the way, the violation that drove the for cause was a shower screw in a bathroom that ultimately was determined by the maintenance department to be an incorrect installation and length of the screw. So the original underlying for cause thrust, which was that they had alleged that
That doesn't really go to the standing issue, so let's try to keep narrowly
not a
focused
problem.
on that.
I understand.
So the difference seems to be that the summary process complaint and the notice to quit say Chelmsford Woods Residences 2 LP.
Correct.
And your contention is that at that time, the landlord was SCG Chelmsford GP LLC.
Correct.
DBA CWR.
Correct.
Right. So what is the judge supposed to do? Well, first of all, was this actually raised to the judge at the time that the lease renewal was before him?
So there wasn't actually a lease renewal before him. This is what I'm trying to state to the court by way of standing. The lease that was presented with the notice to quit and the summons and the complaint was a 2019 lease, which was almost 2 years before that. And this was raised in 2022. So for almost 3 years, that lease had been literally not in effect. So when the lease was renewed in 2020, which is when SCG Development Partners became into the new lease, when the notice to quit was sent, it was sent underneath Chelmsford Woods Residences.
So here's my question. I'm not suggesting that standing or subject matter jurisdiction is waivable, but I'd like to know when was it first brought to the judge's attention that there was a question about whether the party on the complaint and the notice to quit, which is Chelmsford Woods Residence 2 LP, is not the same as the lessor?
After my client had retained counsel.
So can you give us a date or a point in the record?
Yes, so I can state that it would be when I filed in my appearance. I was actually trial counsel. I can see if I can get you the record date. It was a notice of appearance. So that would have been on or about 2/21/2023. It was after my client had been notified by the landlord that they were going to be seeking to issue execution on the nunc-pro-tunc agreement that had been entered into.
So it's difficult for us, I think, on appeal with this record, figuring out if the name of the entity on the summons and complaint and the notice to quit is whether it's the same entity as the entity that's on the lease. And so what I'm getting at is, did you try to flesh this out before the judge? Because they look a lot alike.
I totally agree, and I'm very mindful of the fact that agreements for judgment generally will hold up. But in this particular case, when it got to this single justice and it got kicked back, because the non-protunct agreement didn't have what would happen in the event that there was a violation, it was presumed that it would be able to go to trial or at least have an evidentiary hearing. And this thrusts the gamut of actually this entirety of this case moving forward on the basis of standing, on the basis of having an evidentiary hearing, which ultimately ends up leading to, surprise, at the very end, going all the way through to execution, and then the plaintiff approaching the court to want to vacate the judgment.
But where we don't have a record of whether these two entities are really the same entity or whether there's some kind of privity or assignment of rights, what are we supposed to do here on appeal? Should we remand it to the judge to make findings about whether the entities are the same?
So you could remand it, or it would basically be a moot issue at this point because the entirety of the case has now been vacated as if it had never commenced. The issue that we're here on standing for is because of the secondary issue, which is the prophylactic advice that was given in the order to forbade a abusive process claim or any nature thereof of coming forward in a subsequent matter. The attempt was made on the record on numerous occasions to address the standing issue. It wasn't just addressed in this particular case, it was addressed by numerous other tenants throughout the Chelmsford Wood residences.
Where was it raised in this particular case?
In this case, it was raised in the first instance when I file in my notice of appearance and I make my first motion into the case, and I believe that would have been at docket number, I believe it was docket number 15, and that would be at record appendix number RA0049, and that's when I first make that record.
RA0049.
And I'm making my opposition by way of the fact that the non-protunct agreement, I'm raising all of the contractual issues that exist within it, provisions 1 through the signature by way of the first by the way of the signature from the court, the approval of the court. But it's also important with respect to that non-protunct agreement to also notate that ordinarily in every housing court case, there's usually a prima facie burden that needs to be satisfied by the landlord, and it has to be produced to the trial court judge so that the court at least can make an equitable finding by way of whether or not the non-protunct agreement is even fair and equitable to both parties. And normally there is an inquiry into whether or not that landlord is in fact who it is, and primarily the landlord's attorney is usually in the best position to know her client because she's retained by them, but she's also in the best position to also know who is deeded to the property as well. I, as a tenant attorney and a landlord attorney, I generally will pull the deed just like the majority of tenant attorneys will, just because of the Hatcher issues that arise in housing court cases. They usually are the first line of defense for dismissing out a housing summary process case. And in this particular case, there was another issue arising from this non-protunct agreement, wherein it didn't have all of the necessary and indispensable parties, which was also raised on the record during oral argument continuously.
I'm sorry, can we got only 6 minutes left. Can we fast forward to the agreement of dismissal? Because that, right, so was there, at some point, after all of this, the parties say, okay, we're going to agree to dismiss this whole thing with prejudice?
No, actually.
Okay, so tell me what happens at that point.
Sure. So what happens?
They file a motion to dismiss.
They file a motion to dismiss.
For voluntary dismissal.
Correct, underneath 41A, I believe it was 41A1 initially. Then they wanted 41A2. But the problem was that the case had already gone all the way through adjudication. We had already been before Judge Sullivan in the final adjudication. That was actually supposed to be our evidentiary hearing that never occurred. That was promised by Judge Malamet in a prior order. And because we get to Judge Sullivan on the day of that particular hearing, we get to Judge Sullivan, I have got a courtroom of witnesses, tenants, I've got the certified deeds, everybody. I even have, because we challenged even service of the notice to quit and service of the summons and complaint, we were supposed to be able to have witnesses testifying. But it gets to that point.
To cut to the chase.
I'm getting it.
The ultimate agreement that you submitted, the parties submitted to Judge Malamet after that hearing is at Record Appendix 332, and it says, any and all trial claims as raised by the plaintiff are void and dismissed with prejudice. This action is hereby dismissed with prejudice.
So there never was an agreement before judgment.
Was this
It was an-
agreed upon order submitted by both parties?
No, this agreed upon order, so what had happened was...
This is your agreement. This is your
No,
order.
This is the landlord that came to us after they had the full adjudication of the case, came to the court and wanted to dismiss it as if it had never occurred. And when they did that, I assented in part and opposed in part, and I assented in part to why would I not want my client's order of judgment for poor cause judgment to be vacated.
Did you put something on the record when the defendant filed that agreement?
I did. I filed a motion in opposition, part in ascension.
She's the defendant.
And in
You're the
opposition.
Sorry, oh, okay, so I'm confused. Record Appendix 331 says the court hereby endorses and will sign defendant's proposed order filed
So each of us were
on
asked.
12/24.
So each of us were asked to submit to the court what we would want for a proposed order if the court was to order, because again, I had a part in ascension and part in opposition, and I wasn't sure if it was going to be dismissed with prejudice or not. And so he asked us what we each would like our order to say. And since it was an order and not an agreement for judgment, because there's no consideration being exchanged, and at this point, the whole case has already been closed by way of adjudication. So it was very strange to me. I've never had it happen where I've had to go all the way through to a request for execution to have it state only to have the plaintiff come back and want to basically vacate the whole case as if it had never occurred.
So you submit a proposed order with 4 paragraphs. You add paragraph 2, which theirs doesn't have. The judge signs that one.
They end up signing he ends up,
But he adds one more thing to it.
but he adds I'm going to just call it the prophylactic written language to the order that may or may not be incorporated by reference depending upon how this court finds. But the prophylactic language throws in a barring of any abusive process claim or any nature of an abusive process claim. And I thought this was very discriminatory towards my client, but also a violation of her due process rights, considering this is a for-cause eviction, which means that my client can't even, underneath summary process rules, raise any counterclaim other than retaliation or discrimination. So I would never have had an opportunity, nor would my client ever have an opportunity, and it would be foreclosing her constitutional due process rights to bring forward an abusive process claim, which in this case would, based on all of the other facts that we're deriving from here, would actually support a claim for that. And then secondarily...
So you say there's the kind of counterclaims that can be brought are limited to retaliation and discrimination?
Correct.
Give me the statute site.
I believe it's underneath 239, I believe it's section 8A. It's underneath the statute that covers for-cause evictions. So you can't raise they're not permitted on a for-cause eviction. In a non-payment of rent case or in a no-fault eviction, you can raise all the counterclaims to be able to stay in your property and have $1 and be able to stay in the property. But on a for-cause, it's not permitted. And so as a result, my client gets totally basically foreclosed again, a second time in this case, from being able to protect her constitutional interest to bring forward an abusive process claim or even a malicious prosecution claim for that matter, because it falls underneath the nature of abusive process. So
Do you intend to bring an abusive process claim?
So we actually had always been intending after the case had been done to bring an abusive process on the grounds that the landlord wasn't who it was, that we never got an evidentiary hearing, that the landlord's attorney actually knew, one, who the landlord was, and also because this is a 40B property, it also was subject to LIHTC tax credits. And one of our evidentiary issues that we were going to raise at an evidentiary hearing on that day was to bring forward CTI and to address who actually held the LIHTC credits, since she was being accused of fraud, of not certifying her income, but also not reporting her income, but also being part of a LIHTC property underneath the landlord, which presumably would have been Chelmsford Wood Residences LP, which was managed by Choice Inc., who was the property manager. If the LIHTC tax credit had been under any other name other than SCG Global, right, and it was being brought forward underneath the lease that the government was paying for underneath Chelmsford Woods, there would have been an opportunity to say, well, this is an abusive process, this is a malicious prosecution, and so we were in the process of challenging that. And yes, there are still plans, if the court doesn't foreclose the opportunity, to still move forward with an abusive process claim and a malicious prosecution claim, because this case should never have gotten out of standing in the first instance, and then secondarily, if the plaintiff had, there's no reason why this
Isn't that just, I mean, isn't that just, I mean, if it's an error, isn't it just kind of, Scribner's error? I mean, it looks, it looks a lot like the same thing. You think this is like a malicious thing that they put in the wrong corporation?
It is not, Your Honor, and if the court were to have taken a look at the dockets that had existed at the time for Chelmsford Woods Residences LLC and had reviewed all of the cases in summary, which we did, we took apart all of the cases. There was over 20 cases that were before the housing court specifically from this particular landlord, and almost every one of these cases at some point had raised the same standing issue that we raised here today, that the deeded title, and even Justice Malamud, even in the transcript, had even said that the titled interest is who holds the property ownership interest of it. But then he also in the same in the same order, in one of the footnotes, had mentioned that the division uses and looks at anybody with a legal interest. But we all know underneath Hatcher that can't be the case, because a property manager might have a legal interest too in the property.
Okay.
So
I think we'll have to leave it at, I mean, unless there are any questions.
But I would like to also address the.
You got like 1 minute, okay? Your time is, you're over time.
Oh, I'm sorry, I apologize. If I'm over time, I'll rest on my briefs then.
Okay, thank you. Yeah, the clock goes up. It starts
It does.
going, it counts down and then it counts up.
Thank you, thank you.
Good afternoon. May it please the court, Dana Kerhan for Chelmsford Housing Authority. I guess I'd like to start by putting on the record an audible sigh. I don't know. Let me start out with the standing argument. I think that issue is thoroughly waived in a number of different ways and completely moot. It is not mentioned in the notice of appeal. It is not addressed in a meaningful way in the trial court. I think the first thing I would have done is, were I representing her client and making this allegation, is I would have raised it in a motion to dismiss and litigated that issue, and that really wasn't done.
But you agree subject matter jurisdiction can't be waived?
I suppose it can't be waived, but, here's the problem. I mean, on the lease, this entity, Chelmsford Woods Residences 2 LLP, is listed as the owner of the property. In the stipulation, the nunc-pro-tunc order stipulation, it was conceded that Chelmsford Woods 2 LLP was the owner. I mean, I've handled a number of these housing authority cases. A lot of times there's a split between who owns the land and who owns the buildings. And I don't know if that's the case here. It may very well be the case, but I think ultimately, though, if my sister is right, the remedy is that everything gets dismissed. Well, guess what? Everything's been dismissed. So, I mean, we're not any place.
Yeah. Well, everything's been dismissed with prejudice.
Yes.
Everything that was asserted. And then there's this additional provision regarding no abuse of process claim. If the tenant is right about standing, then everything would be dismissed without prejudice. Does that make a difference to your client?
I'm not sure if it makes a difference to my client, but I also think, I don't think what the judge did was said, you can never bring an abusive process claim or you can never bring anything, any other claim. The parties appeared in front of the judge and said, you know, we've resolved this, we want it dismissed with prejudice. Both sides, and this is Record Appendix 324 and 325, submitted proposed orders that the action be dismissed with prejudice. Now, the landlord had an additional provision and said, any and all claims or issues relating to or concerning this action that were raised or could have been raised are waived and or dismissed with prejudice. That is not in the tenant's proposed order. What the judge did was kind of split the baby and said, the agreed to dismissal shall bar any claims in the nature of abusive process arising out of this matter. So, I mean, it is not a blanket, you can never bring any claims, you can never bring an abusive process claim, you can never, if anything happens, if they try to do anything to you in the future.
Sure, in the future, but what he's saying and what the tenant appears to be concerned about is abusive process claims arising out of this matter, the one that he's dismissing.
Yes, I mean, I think the judge was entitled to make that, that finding. The judge essentially said, look, come up with an agreement and bring me an order and I'll sign it. And if you can't, I'll make a margin order. And that's what he did. And he did not go as far as either party had asked. He kind of went sort of straight down the middle. And
it's pretty clear that the tenant did not waive her right to bring any counterclaims or other claims that could have been brought in this case. And in fact, the judge in his handwritten order says that. The parties did not agree in open court to a waiver of all claims that could have been made, which would have had to be explicit and knowing. Counterclaims were never filed in this matter. No counterclaims in this matter would be compulsory, which are the only claims that would be appropriate to dismiss with prejudice without defendant's explicit approval. So it seems like he's setting up a long rationale there for why he's not going to dismiss anything, any claims that could have been brought with prejudice. But then he adds a tagline that says, this claim that could have been brought, I'm foreclosing.
This one claim, and I think there's no legal basis for bringing in an abusive process claim.
Well, that might be, but isn't the way to deal with that to have it asserted and then move to dismiss?
Well, I mean, I'm hoping we don't have to get that far, because I think we did, in spite of the judge's language saying, you know, you didn't agree, they didn't in open court agree to everything, they did agree to dismissal with prejudice of this whole mess, this whole litigation incorporating a couple of, you know, the two evictions, or the two attempted evictions. And, you know, I think it was the intention of the parties to sort of dispose of the case. Now, you know, the issue that, I would have filed an abusive process claim, or I intended to do that. That really didn't come up until after the whole thing was dismissed and after the judge entered his order. And, you know, all of a sudden, oh, here's an idea, I can sue for abusive process. I mean, I don't think there's any legal basis for that. And I think the judges, in view of the parties' agreement, I think the parties' agreement really did incorporate that particular claim. Not in a general sense, but as it related to the two attempted summary process actions.
So I'm looking at Rule 41, and I think we're in 41A2. And I mean, it does say that the court can dismiss under such terms and conditions as the court deems proper. But then it goes on to say that it can't dismiss counterclaims unless the defendant agrees. He also says they didn't agree to that.
Well, I mean, there wasn't a counterclaim. There were no counterclaims.
Right. So, I mean, so he's dismissing well, actually, they couldn't even brought the counterclaim. They couldn't even brought that as a counterclaim.
I mean, it would probably have to be a separate action, but, you know, nobody got the idea of bringing that separate action until after the judge mentioned it. Maybe he shouldn't have mentioned it. So, you know, I've been trying to make heads or tails of this case, and I think the judge did the best he could and got it right. I mean, there's really just nothing there, and you know, to go back and say, well, you can sue the landlord for bringing this action in the first place. I mean, it was a good faith action. Yes, they did. I guess they did find that it wasn't the fault of the tenant that there was some flooding and that the other issues didn't involve anything improper. But I mean, everything has now been dismissed. The tenant is still in the apartment and has suffered no adverse consequences as a result of this. So, and again, I think if the remedy for all of this, you know, for what she's complaining about, I think she's already got it. Unless there are any further questions, I will leave the remaining points of the brief.
Okay. No, thank you. Thank you both. Concludes a very interesting day. And I want to thank the clerks and the court officers, and we'll be in recess. And everybody have a good long weekend.